So we'll kick things off though. So welcome to day 10 and the final hearing day for the Victorian Murray Floodplain Restoration Project EES Central package relating to Belsar, Yungra and the Hatter Lakes North Floodplain Restoration projects. And this hearing is being audio recorded along with the other days, and the audio recordings are available on the Engage Victoria website, and today's will be uploaded within the next few days. So my name is Lisa Kendall and I'm chair of the committee considering EES Central, and I'm joined today by my colleagues Member Kirsch as Deputy Chair, Member Bell, Dr Brisker, Member Carruthers and Member Ham. And just to confirm, as parties are aware, Member Ham is with us for this morning's session only. So in terms of our timetable, as today we'll be hearing closing submissions from the proponent. We have received a number of documents. Thank you very much. I won't read through all of the documents and the document numbers, but I'll note that they are available on the parties shared document website, and that the document list version 35 has been updated and uploaded yesterday. So thank you to the proponent for your final tech notes, Part C submissions and attachments. Just a couple of preliminary matters to cover off this morning, and in anticipation of needing to ask Mr. Decker from DECA to speak, I'll just ask if he could please be given co-host status, but we'll come to that issue in a moment. Just for the benefit of all parties, a reminder that the committee did or has issued directions asking parties who are interested and would like the opportunity to comment on the proponent's final day versions of project documentation on a project on a without prejudice basis, have 5 business days to do that, so required by 12 noon on the 15th of February. And I will remind parties of that towards the end of the day again, and to emphasise that it's not an opportunity to revisit any matters of merit, and comments must be restricted to drafting only. And I note that in the documents circulated by the proponent, we do have copies of those final day version documents in both a Word version and PDF. So one other preliminary matter before I open up to ask if there are other things we need to discuss before we start this morning. And I'll just check that Mr. Decker is with us before we... Yes, I can see that he is with us, so hopefully he'll be able to join us in a moment. So the committee received an email from DECA Environment yesterday seeking to understand if there was any process for responding to new information presented during the hearing. So I will ask Mr. Decker in a moment to speak to this request, and I'll ask for the proponent's views and any other party. Noting, just for context, that DECA Environment, while initially requesting to be heard and speak at the hearing, advised at the beginning of the hearing process or the directions hearing that it intended to observe, respond to any questions the committee may have of it. And through the hearing process, while a letter was issued with questions from the committee, this was later withdrawn by the committee, and as an alternative, the committee accepted the proponent's suggestion to make additional submissions relating to native vegetation policy as part of its Part C submissions that the committee has received. So in that context, I asked Mr. Decker if he could please explain exactly what the new material is that he's looking to respond to, and what exactly DECA Environment is seeking from the committee in this regard. Thank you, Mr. Decker, and welcome.
Thank you, Member Kendall. I appreciate that and the opportunity to note and flag this matter. DECA has noted that new information has been presented during the hearing that was not available for consideration when we initially prepared and lodged our submission, and that includes the expert elicitation result and reports, the attachment to Part C with respect to native vegetation policy, and the technical note number 13, particularly with respect to questions that were raised to Mr. George. Additionally, with respect to consideration of native veg policy and the interests of the Secretary, Tadika, matters contained in attachment to Part C submission, Victorian native vegetation policy, and whether it responds to the committee's questions initially posed to DECA, but on the 27th of Jan, but subsequently withdrawn and redirected. DECA previously advised that to the committee that it's not in a position to offer any judgment or opinion-based positions, especially with respect to merits of the project. However, it's also advised the committee that we're more than happy to assist with advice of technical, factual, policy neutral nature, of which we considered many of the questions contained in the committee's initial questions dated 27th of Jan to be. DECA wishes to make further submission on the matters with respect to native vegetation policy and bushfire, and considers that this will assist the committee in its consideration of these matters. And we're happy or open to direction of the committee on timing and process and means, but we believe we would be able to have something in writing by the end of the week. Thank you.
Mr. Decker. Before I do seek the views of the proponent, I believe you will understand there is the opportunity to provide comment on the project documents, the final day documents, and just to clarify that what you're wishing to provide to the committee is outside of the scope of those directions. Is that correct?
I'm sorry, Member Kendall, I'm not sure I understood the question.
As I just described earlier, the committee did include directions for parties to have the opportunity to provide comment on any of the proponents' final day versions of the project documentation by Wednesday. I think it's Wednesday next week, 5 business days after the close of the hearing. My question of clarification to you is, are you seeking to provide submission beyond that direction of the committee?
No, I may have overlooked that direction, Member Kendall, and I do apologise if that's the case, but I would not imagine that it would be outside that scope if it includes the ability to provide comment in response to the results of the expert elicitation and what has been tabled as part of attachment to Part C submission.
So the direction, I'm just going to take you to it. So it's the original committee directions 42, 43 and 44, which explicitly state the process is not an opportunity to revisit any matters of merit, and comments must be restricted to drafting only.
Could I ask that I have the opportunity to go over those directions 42 and 44 and advise through today?
Come back to the committee
come back to the committee on that. Yeah.
It's something I'd like to resolve fairly quickly. I'll just ask the proponent now for its comment. I think it's gone into slightly greyer territory as a result of that question and answer, but I'll still,
apologies,
if we could get some clarity from the proponent on your perspective for now, that may assist Mr. Decker in resolving the issue quickly as well. Thank you.
Thank you. Look, Member Kendall, my main focus in assisting the committee is that we keep the process and procedural aspects very much on the rails and protect the committee's role, which is to give government advice, not receive it. And so I am a little perplexed by the request, but there's a couple of misnomers in there, and it might just be a misunderstanding. The first comment, which was the second question in the email, was about the withdrawn questions. And I understood Mr. Decker to call them withdrawn and redirected. That's not the position. The questions withdrawn, and we had explained carefully why, as a matter of legal principle and process, and the importance of the Minister for Environment and the Secretary refraining from giving advice to the committee where it will be receiving it, sat behind the issue we had with questions that really sought matters of officer advice or opinion around matters which A, aren't central, but B, are not appropriate matters for advice to an independent committee. So the withdrawal is not a redirection. We didn't see those questions as being appropriate to be answered by anybody, us or DECA. And so I think that's a misunderstanding, which might explain the second request or comment in the email. But the first point also requires further understanding. We would say we remain a little perplexed about it. The appropriate position that we support, as our colleague department had put to the committee, was that it only wanted to observe and would respond to questions as they assist the committee. That's the appropriate approach in these matters. Secondly, questions that assist the committee are obviously matters of clarification the committee seeks. Is that the right map? Is this that? Is that the right clause? Not what do you think? Once you get to anything, no matter how it's described, that is a submission on the merits, the committee is squarely not assisted, and also potentially runs foul of the process by which the Minister and the Secretary, in fact, you can just say the Minister, because the Minister can direct the Secretary, must wait the Minister's assessment. So it begs the final perplexing question for us, and again, I don't mean to criticise, but we don't understand who's making this request. If the committee were to receive anything in the nature of a submission that might cross into merits, and particularly if it supports us, we don't think that helps us at all. The committee ought to know that it is the Minister making that request, the Minister for Environment, or the Secretary, and why, and be very cautious that it's not officers. Officers may be assisting their Minister or Secretary down the track, but we don't see some independent authority of the officers to give officer advice to this assessment committee. And we don't understand how the committee would be assisted. So as we said the other day, if advice of that nature crossed that line, we would have to make submissions to you to disregard it. And the safer thing is to commend the officers for their first advice to you, that they're observing only. And if there are questions that would assist you, they'd be happy to respond. But now with that very heavy qualification and thoroughly understood qualification, that they're not assisting you if you're getting officers' opinion or argument, which they might have commended or provided to the Secretary or Minister, who's an ultimate decision maker, and ought not be making comment in these proceedings. Mr. Decker is not separate from his Minister for these proceedings, cannot be separated from his Minister. And if he was to make a request, we'd be happy to see it, but it ought to be coming from his Minister. So that's our response. We think there's just an unsafe relationship between what's been raised and keeping the hearing on the rails. But we would never prevent the committee asking anyone in government for assistance on a matter that's of assistance, not of opinion, argument, merits, or comment. And in those circumstances, it's absolutely appropriate that agencies are on standby to assist you. But I would have to say, in the with the lack of clarity of how it's put this morning, I wouldn't discern that the committee could have confidence that what you're being asked to receive is not in the way of comment, argument, or officer opinion, which you should avoid.
Thank you, Mr. Townsend, for your views. I will, hesitating to, I don't want to open the floor up on this issue. I think it's more of a closed issue that we can resolve between Mr. Decker and the committee. So Mr. Decker, having heard that, could I come back to you to see whether you have any further comment or suggestion?
Thank you, Member Kendall, and thank you, Mr. Townsend, for that response. And yes, we have the same desire in ensuring that we keep the hearing on the rails, so to speak. I will have to apologise in not being across the directions 42 and 44, and maybe I need the opportunity to read through those directions and see how they would be in keeping with our desire to make a further submission on matters that we considered to be new information that we did not have available to us at the time of the preparation and submission. So preparation and of our submission and forwarding that through. I'm not sure if I have much more to offer on the spot. Would appreciate the opportunity to review direction 42 and 44 and maybe get back to you throughout the day.
Thank you, Mr. Decker. So just to try to wrap that up from the committee's perspective, I can confirm the committee is not seeking further advice from DECA at this stage. So there's no specific questions that we're looking to put to DECA to clarify any of the policy or regulatory requirements or in the context of the matter before us. I would be very reluctant to open up for further exchange of any submissions or content of merit. And I understand and accept the position of and explanation of Mr. Townsend on the procedural complications. It is late in the hearing, and on the basis that DECA's original intent was to observe and respond to questions, which the committee accepted and was comfortable with that approach. So just in that context as well, Mr. Decker, I will consider the matter resolved that DECA will potentially comment on the final day documents within the context of the directions. You are welcome to talk to the planning panel's office if there's anything else that you want to follow up, but at this stage I'm going to consider that the matter's resolved and that we may hear from DECA through that process of exchange of information on the final documents.
Thank you, Member Kendall. Understood.
Thank you. Before we do move into the closing submissions, I'll just ask if there are any other preliminary matters. Firstly, Mr. Townsend.
Two practical by way of documents. I'm instructed this morning that the tech note for the Living Murray questions did not hit your inbox yet, but it's imminent. I'm not sure the reasons, but I'm sorry that it's not there yet, but it's close. And I'll draw that to your attention. Or Mr. Forrester will be going to that for you this afternoon anyway, so you won't have to have read it. But the second is again an apology in advance. The drone footage where I had, with much fanfare, said was being labelled to give you some direction. I haven't seen it, but I understand that one way or another it ended up in a comms department with sort of music and narration and things that you wouldn't do at the end of the hearing, you know, that you do earlier. So we've asked it to be sent back and stripped back to directional information and to take out the sort of narrative. I apologise for that. We still intend to do that, and it'll be in a manner you can deal with it, but we only wanted to do it to be strictly providing direction and not giving any comment. And so my apologies you haven't got it this morning. And I can come back to you later in the day, perhaps with the feedback on when it would be filed. I hope you understand. I didn't want to put something in that any submitter might think was sort of glossy. I just wanted to give you something that was point and shoot.
Yes.
Yeah.
Thank you. That's clear.
I
and
apologise. It's
that.
our mistake, but yeah.
If we do have any questions when we've received it, that material comes in later, then we have time to review it. We'll come back to you with any questions. Thank you. Could I ask if there are any other parties with preliminary matters this morning? Great, thank you. Well, we'll keep moving. Mr. Townsend, if you could take us through, I know in your submissions you've given us an outline of how you propose to present your closing today, but if you could run us through that.
Right. Yeah, I think that's a good start. I think you've got a general picture, but we've got some other reasons why we need to do things in a particular order. Can I just mention that Member Ham is with us, is he? I don't see him,
I can. Yes, and I am.
If I don't know if that's a malfunction or if Member Ham intends to be listening but not there, that's fine.
No,
too. Yeah,
there we go. We've just he's arrived in visual form as well. Welcome, Member Ham. I know you've been with us through the morning already.
It's just the camera wasn't on. That's fine. I just wanted to be sure because obviously part of what we need to do must occur with Member Ham's more limited time to this morning. And so what we've got to get through today is I was going to identify for you the Part C submission and in the introductory parts effectively. As you're aware, the document we filed in advance on the Monday is effectively an attachment to the Part C, and we'd ask you to have both those documents generally available to you for the course of the morning. But there are two mini sessions that we need to get through where I've got assistance in our presentation and submission from those who can answer any question or clarification on the run better than I can. There are two presentations. One's the traditional owner engagement, and the other one will be later in the morning with Ms. Chapman, as we've indicated, on explaining the tool or the metrics on the exercise to measure benefits. If I could just focus for a minute. I beg your pardon. I'll come back to that. Then I'll go take you through the balance or the thematic sort of approach we've taken in the Part C submission without reading it fully to you, but reasonably faithfully to it. And I'm hoping to get all that done as close as I can to lunchtime or soon after. And then Mr. Forrester is going to take you to about 6 or so of the technical notes for some particular matters we just wanted to ensure had become clear and which link back to matters I would have taken you to this morning. And then with Mr. Forrester having the screen, you'll go to some specific matters on monitoring, evaluation, reporting, and the day 2 documents. So we've got a fair bit to get through. I undertake to keep pushing everybody, and we're confident we'll get there today. But if that's a sufficient opening explanation, what I'd like to do is ask the committee to have our Part C document filed yesterday open to it, and to just point to you that there is a detailed index or a contents page on the front, so you can see how that flows. And of course that the attachment to it is the Monday document, being the native vegetation policy submission. Attached to this document, you'll see what you received last night were the slide presentation came through that Ms. Chapman will take you to, I think, after the coffee break on the vegetation assessment, and the update on the traditional owner consultation update. And I'm going to be getting to that quite quickly for reasons I'll explain just now. But first, can I thank the committee for your response to our letter and request around confidentiality, and we were comforted, I might say, by that answer. It just removed an issue of going into confidential items that we appreciate. The confidentiality associated with this project, of course, is not limited to the hearing, as you may recall and have seen. Even at exhibition stage, the public exhibition of the relevant specialist assessment was heavily redacted, and that was if you like, the department at the time appreciating, in the same way as the term of reference, we took your attention to these matters involve real sensitivity, and so there is even in the public exhibition heavily redacted information that we don't intend to be taking you to, but we know the committee has an unredacted version. So in a sense, you have a closed session, as it were, in the EES materials. We had prepared, as we said we would, an update that we would have used in the session, but as I think I said to you the other day, was being prepared in a way that could be publicly shared as well. So the attachment to this submission called Traditional Owner Consultation Update is the document that we would have freely shared, subject to any questions of the committee that might have been more of a detailed nature, and which we're pleased we don't have to take you to. And I'll read you through our cultural heritage aspects of that and more about the matters I've just addressed you on when I come to that part of the Part C submission. But what's happening is that you'll see in the, if I can ask you to turn to the update, I won't screen share it yet. We might, in a moment. But if I can just with a nod make sure in particular the committee members and that Member Ham have got that available to them, the attachment, the update, because without delving into confidential matters, we're able to put that update to you with, and I've got assistance from Mr. Callum and Mr. Watson. The complication is that Mr. Watson, who coordinates, has been coordinating traditional owner consultation via CMA since 2019, is currently convening the sessions at Mildura this week. Last week they were at Swan Hill. This week they're in Mildura, and in fact Mr. Watson's there now, and he's proposing to leave those meetings at 10:30, come and appear on screen to answer a couple of explanatory matters to help me, but then disappear back into the traditional owner meetings that are currently taking place. So I had indicated to him that if he could be around at 10:30, I know he had the screen on in the background, I think. And so what I wanted to do, if it was all right, a bit out of order, was get this over and done with now so that I can let Mr. Callum and Mr. Watson get back to what they're doing and just show you this this document. It'll take me about 10-15 minutes, I think, to get us through it. So we've got Mr. Callum on screen. Can I invite Mr. Watson, if he can hear me, if he's freed himself from the meeting he's in? There he is. Thanks,
Great,
Mr. Watson.
thank you. And Mr. Townsend, just to confirm, we're talking about a document 175, attachment to the Part C.
That's correct. And I'm sorry, I should have given it a document number. I've printed it, so I've got it as a physical attachment, but you're right. It's a separate document, document 175. We'll screen share it in a moment through Mr. Forrester's screen.
Thank you.
Look, it was really set up as a walkthrough document to assist with these matters. The only difference we now comfortably we can proceed on, that we won't be delving beyond the more generalised description we can offer here to matters of personal or confidential nature, and we're very pleased about that. But what I might do, if it's all right with you, members of the committee, is invite you just to look at that document on your own screens for a moment, and I'll just show you the headings and then how I'm going to, because I'm only going to ask Mr. Watson something briefly in a moment so he can go again. The consultation team, there's like a flow chart that just explains how that works. Mr. Callum will do that in a moment. The timelines, Mr. Callum will be able to do, which are going to explain for you the context within which consultation for these projects sits, given the enormous amount of consultation overlapping for various reasons up in the area, and why under our comment we've made under the heading timelines, it's the experience of the projects that there's a high level of, or a reasonable level of familiarity with water policy and environmentally water programs in the area. It's not just because of these projects, and there's a very long history around that, and obviously a relationship with the same consulted persons. The who was consulted list is, and the snapshot nature of meetings are really where Mr. Watson comes in. And what I'm going to do when we get to Mr. Watson is really ask him to flesh out for you simply the nature of meetings, in his words for you, what consultation looked like in general terms. And I think you'll be impressed by the sheer direct engagement and how personal it is, and how that's done. And I'm not going to ask Mr. Watson to mention individuals as such, but to give you a general flavour. The snapshot that we've provided there is of a document you could have seen in a closed session. We won't show you, but obviously it identifies persons throughout and meetings and when and dates and all sorts of information that we were able to consolidate for you in a snapshot, so that you've got something the committee can see just as in quantum, but it's the nature of that Mr. Watson will expand on. And then I'll come back to what it meant for the projects when we get to the balance of the headings. So what I'm thinking of doing is, first of all, the committee knows who Mr. Callum is. You saw him on day 2. Can I just introduce you to Mr. Watson? First and foremost, he's on screen. And Mr. Watson, you've heard me say we know you've got limited time, but Mr. Watson, can you just tell us who you are and what your role's been since 2019 in association with the projects?
Yeah, no worries, Chris. Obviously I'm a traditional owner, so the people that we're talking to and everything else is very close to my heart and ground as well. My role in the CMA is obviously to keep that separated on a professional level and keep all the groups and that up to date with what's going on with the project before, after, during, and yeah, keep people completely up to date, be open and transparent with everybody, and keep moving forward. So yeah, basically keeping groups aware of what's going on with this project, getting their voice to put into this project, and actually incorporating their voice into this project. So that in essence, that's my role.
Yes. And look, Mr. Watson, while I've got you talking, in the document, if Mr. Forrester just shares it, under the snapshot, there's we've summarised 288 recorded interactions and described them in terms of site visits, meetings, emails, and this is the 2019 period under your watch, as it were. Can you just perhaps confirm, without going into detail about them, that information comes from your detailed inventory of the various meetings you've had across that period of time?
That is completely correct.
Yeah. And what I might do to save time for you, Mr. Watson, is I think we can take that as a quantum, as a volume of information as sufficiently presented there. But can you just give a bit of a description of what's under nature of meetings for the committee, about what on the ground, what your consultation looked like or feels like, if you like, having regard to all the different methods and ways you've met with people over that period of time under the heading nature of meetings?
So the nature of the meetings have always been open, transparent to whoever wants to either give a phone call, have a house meeting, meet on country somewhere, get updates. So if somebody's given me a call, they're interested in the project, or an email or anything like that, we actually organise a meeting, catch up face-to-face on face-to-face values, and include them into up-to-date wherever we're at or what we're coming to, and include them in the conversation. So it's a very in-depth phone calls, face-to-face meeting, which just doesn't stop. It's a 24-hour, 7-day-a-week event. Indigenous people, as we all know, we have our ways of communication, and generally it's all hour of the day. So yeah, it's a full-on task. It's on field trips, yeah, and the convening up to that field trip is countless phone calls and interactions prior to it. A lot of house visits, travelling across the state to actually knock on somebody's door because they've requested to catch up for a meeting, or we want to fill them up to date and get them up to date with what the project's happening, or what's going to happen, or what we hope to happen, to meetings and everything else. So when I'm saying all across the state, I'm talking all across the state. It is a very open project, and everybody has had an opportunity to get in contact and be a part of it. Regardless of their determination of what they think of this project, we've always took it on board, and also taken their views and brought it to the table. So that's all through the formal meetings and breakout sessions and everything else through meetings. If a particular person wants to introduce something but doesn't want to bring a voice to the table, I have brought that to the table throughout meetings, and things have changed from them issues brought to the table in different sensitive ways. So
yes, I might just scroll up. If we just get Mr. Forrest scroll up, this you don't have to spend long on this, but if we go up above to who was consulted, what would you say to anyone who might say to the committee that they weren't invited or didn't feel included or have the opportunity to join your consultation?
everybody has been sent out an email. We've emailed First Nations Legal and Research body. So if anyone if I had ever missed anybody or they had questions and couldn't get hold of me, they had that side of things in email, so they were up to date, that they could transpire and send out to anybody that requested it. We've tried time and time again with some people, but they just refuse to be interacted with, which is their call. That's fine. But there are members of every group listed even there that have attended and shown very much interest in the meetings and deliberation of this project.
Yeah, and most recently, I might just get you to give a very brief explanation of, without going into what's been discussed at them, just tell us the nature of attendance and the days you're spending together, last week at Swan Hill and this week at Mildura.
Okay, so last week was a lot of groups together. It was all in discussions around conditions. So what cultural heritage needs to be preserved, how they would like to preserve it. And that went for a duration. And this week is pretty much the same thing, which is bringing the voice into the project, where the deliverables are coming from the traditional owners and the interested parties of the areas. For instance, here we have 5 groups here today that I'm doing the same conclusions with.
Yep, thank you very much. I'm conscious, Mr. Watson, that, I mean, you can stay or go after any questions from the committee. I've got Mr. Kellerman to do a couple of jobs yet. And if you're staying online and listening, that's great. But if you've got to be in the other meeting, we understand that. I'm sure the committee does. But I just would ask at this stage, Mr. Watson, whether Member Kendall, if Member Ham or anyone on the committee wanted to ask Mr. Watson. Mr. Watson knows he knows if it's confidential and he won't say something, but if there's anything of a general nature, I'm sure Mr. Watson's happy to answer.
Thank you, Mr. Townsend. I will just check with Member Ham if he does. I could see your thumb ready to unmute yourself, Member Ham's working system. Thank you, Mr. Watson, for coming along, and I will hand you to Member Ham for a question or two.
Thank you, Chair. Mr. Watson, thank you for that. It's a really good overview of the depth of engagement. I do just want to clarify again, or if you could expand a bit further. You spoke about you've asked many people to engage, and it's up to them whether they choose to or not. Has that been over a period of time, over a period of years, for example?
Yes, that's been since 2019, since I've started right through. It's a continual ask, and even though they don't want to be a part of it, which has been explained to me, we've still constantly, I've constantly sent them emails and updates, so that if they did happen to change their mind, they're actually up to date with what the project's going ahead with. Sorry, Mr. Ham's frozen on my screen.
Mine too, Member Kendall.
Yes, me too. We'll just give him a minute to see if we can get that working. Apologies for the hiccup at our end. Just while Member Ham is, I think we've got you back, Member Ham. I'll just check. Not quite. No, we've lost him completely.
I assume he's logging back in.
Yes, I think he will be.
Sorry, Chair. Yeah, I think his internet may have just died, so he's just re-logging back in.
Thank you. Apologies, Mr. Watson. I have a question for you, and I understand Member Ham's not here, but will relay the answer to him. It's just a question of clarification for you from that written material that's come in, the statistics or the data that Mr. Townsend took you through the snapshot. Just to confirm, was that all from 2019?
That's from 20 right through. Yep.
For a year? Was it for a longer time frame? Or?
From 2019 through to 2022.
Oh, okay, thank you.
But so there's actually more meetings and everything in there that haven't been seen. So there is actually more personal meetings and everything in between that as well.
All right, thank you for the clarification. Hopefully we've got Member Ham back. I can see you're still on, your microphone's still on mute there, Member Ham. So we'll see if we can, there we go. Wonderful, thank you. Welcome back.
And I'm back off my phone and on my computer. It was just following on from that last question. So regardless of whether people choose to participate, they are aware of the progress of the project, where things are at, and what's being considered at a particular point in time.
Yes.
Yes. Yeah. Okay. That's the questions I had, Chair. Thank you. Thank you, Mr. Watson.
Thank you, Member Ham. No further questions from the committee. Thank you both to Mr. Watson and Mr. Townsend.
And Mr. Watson, you can stay or go. We know you're somewhere else, so if you disappear off screen, we understand. But I'll get Mr. Kellerman. I think we're going to put this more in a governance context for you too. So, Mr. Kellerman, we might have Mr. Forrester screen share the part of the document that just shows how what the full consultation team looks like and how it interacts with the projects with VMFRP. Just so there's a clear understanding around that, and then I'll take you to the timeline document. Is that all right? So do you want a screen? I'll get me there. It is. Can you just, don't take too long, but the point being, I think it'll assist the committee to see that interaction between your roles and the project.
Yeah. Well, good morning. Good morning again, committee members. So what you're looking at here is a condensed version of our org structure. It's just showing the roles that are of relevance to engaging with traditional owners and Aboriginal community members across our catchment. So from the left to the right, you'll see roles which are substantive within the Catchment Management Authority. So those between Aboriginal Water Officer and Executive Manager engagements are substantive positions within our business, which partner with traditional owners to breathe life into their aspirations or get their involvement into environmental watering or related directly to the Living Murray projects. On the right-hand side, the more vertical structure you see is the Victorian Murray Floodplain Restoration Project, which we host all of the traditional owner engagement roles within our business as well too. So they're very much a part of our structure at this point in time. And as Mr. Watson described to you, they engage with and benefit from the relationships that the substantive organisation has created and will feed back into the project Aboriginal voice to affect change based on the values that might be present in the landscape.
All right, well, I think that can be that shot. If there's any questions, can come back to you. I'm going to keep this moving, if I may, Mr. Kellerman, straight to the timeline attachment to that document, where I think what you wanted to explain to the committee goes to just the context within which consultation is overlaps with other. I think it's a bit of a challenge to take that slide at face value, but perhaps you give us a 2-minute walk through it.
No worries. And yeah, look, this again doesn't contain everything at all, but it's a couple of inflection points, I suppose, along the journey, which will provide hopefully the members some idea of, this hasn't come out of the blue and isn't something which has just arrived on the doorstep. And, the whole idea of literacy around understanding how our basin operates and the threats that come to it are not things that have arrived on the doorstep of our community just in the last 2 years with the VMFRP. They date back quite some time. And so we've taken the start of this snapshot as 2003, when the Living Murray program began. In 2004, we had emergency watering programs at Hattakulkine National Park to prevent the site from ecosystem collapse. In 2006, that Living Murray program instigated the position known as the TLM site Indigenous facilitator role, and that was really the pioneering of the strong partnership. That was filled by Uncle Kenny Stewart, who worked with traditional owners and brought them on the journey through environmental watering to the development, which is, some emergency works through the millennial drought, into a more permanent solution, which is the Hatta Coalcoin works that we have today. In 2009, there was fieldwork surveys in both Hatta South and North, because North was contemplated as part of the Living Murray works. So traditional owners on shared country, and that's an important point. When it's shared country, Uncle Kenny brought the traditional owners together at the time to complete the CHMP works back in 2009. By 2012, the Living Murray Icon Site Indigenous Participation Program began. And that's two roles which sit within our organisation to this day, and has formed lasting relationships with community at the icon sites, and involves that community in the operation of the sites and the monitoring of the sites. So that's Hatta Coalcoin and Lindsay Michael Walpola, which will be subject to a later EES. In 2013, Living Murray project was completed. Hatta, the construction works and the first watering was delivered. And at that same time, the SDL business cases were being developed with concepts, and there was a 3-year consultation period that led up to 2014 with letters of support from representatives of traditional owner groups at the conclusion of that and submission of that business case. So there was certainly a lot of engagement that occurred prior to 2014 on the SDL concept. Moving forward to 2016, which was when I first joined the organisation, this was a real, it's burnt into my psyche, was we took traditional owners back out, or traditional owners really took us out to Hatta to observe the outcomes of the first 4 years of operations, and that's encapsulated in a YouTube video that's publicly available. I've got the link there too, but it's traditional owners talking to their experiences of returning to Hatta after those years of operations. 2018 was a real change for the state, and that was the development of the Aboriginal Partnerships and Water Officer, or it's the Aboriginal Water Officer Network, as a part of a broader suite of investment from DELP. And we host in our organisation an Aboriginal Water Officer who works with the non-RAP groups for input into annual watering priorities and broader floodplain restoration outcomes. And so that role's been hosted with our organisation, and particularly focuses on that shared country between Swan Hill and Hatta, which is where our RAP kicks in just north of Hatta. 2019 began the formalised Talk Water events, which is hosted by our Aboriginal Water Officer, which are on-country trips with traditional owners to observe the benefits and disbenefits and all the issues that exist on floodplains, and provides direct voice into the seasonal watering proposals. In 2019, this is when VMFRP really kicked off again for this second round. SDLs had been around for a long time but hadn't really grown legs, and they did in 2019. And so there was a lot of engagement in 2019 to refresh groups who had been involved back in 2014 on the VMFRP concept and the CHMP process that would ensue should they wish to be involved in that. In 2020, the fieldworks commenced at Belsa, and actually there was something I missed in this that I meant to say to you as well too, and that is in 2016 there was some CHMP work completed at Hatta North as well too under the SDL banner. And it's probably worth also saying, because we are on shared country, there is obviously differences of opinion both between and within groups, and as Mr. Watson described, we work respectfully with all. So the door is open for all parties to be involved, and should they choose not to be involved at that point in time, that doesn't mean the invites or the communication stops at that point in time. That's fine. We've taken the obligation to make sure we engage with traditional owners and reflect their opinions accurately and unchanged. 2021, we also commenced a project known as the Aspirations Project, and that's working in VMFRP landscapes on non-VMFRP related things. So it's working with traditional owners on their aspirations for that site, and we've got the capacity to deliver on self-directed projects with short and medium-term goals. And they might be, there's a bush nursery concept, which is nursery for children, not nursery for plants. Intergenerational learning outcomes, there's opportunities for creating business cases to procure or take responsibility for government-owned land, which is not in a national park but adjoins. There's revegetation of plants of cultural significance. There's a lot of projects in that which are working with traditional owners on things that the VMFRP doesn't directly deliver upon or will be beneficial to. So that project started in 2021 with all groups. who want to partake. In 2022, the fieldwork was completed at Hatter North for the Cultural Heritage Management Plan, again with traditional owners present. What I've missed in there is we've been delivering some Aboriginal waterway assessments at Hatter under the Living Murray program as well too. In 2021-22, we've been working through EES consultation. So that is working through the process of EES, which was new for a lot of Mallee CMA staff, let alone community members as well. So we went through the journey of what an EES is and how that will impact on or what it catalogues, and all the individual specialist assessments. And then in particular of interest was cultural values and aspirations, and surface water assessments was also really of interest to traditional owners. So those consultation activities took place between 21 and 22. In 2022 as well, we were partnering with traditional owners to get input into and start creating the environmental water management plans and operating plans, which must be considerate of cultural values for both Hatter and Balsa. And also now the consultation, as Mr. Watson described, is around management conditions that will sit within CHMPs, but also the conversations now turning to how traditional owners would like to be a part of the construction activities that take place, where there's opportunities for employment through construction, but also then what their role will be in protecting values and making sure that, you know, the conditions that are collectively set are complied with by the construction authorities. And so conversations around, you know, regular site visits and tours, etc., are taking place, and that's ongoing work that will continue into the early part of 2023 at this point.
All right, I'll push on and then invite Member Kendall if there's anything you want to ask Mr. Kellerman in a moment, and just show you the balance of this update, because I want to keep moving. And I might ask Mr. Forrester to go back to the heading, how views about the projects are communicated to the project owners. The person at VMFRP responsible for this, who would have come if we'd had a session or at the original plan, is actually at the Mildura meetings as we speak as well. So I'll do my best on this, but take any questions from the committee if you want us to come back to you. But the point, as I understand these points, is reasonably straightforward, that once between Mr. Watson, once on the projects, as opposed to the broader program, once it merged into the EES, if particular concerns were arising on particular locations, a meeting would then be convened by Mr. Watson through with the VMFRP team project manager, and often they would then, if necessary, go to land or use mapping. It would depend on whether it was the nature of the issue and how sensitive to culture, men's or women's business, for example, and discussion around who should go. And then there would be scope or design change around that item. Now, within the specialist assessment, although redacted, there are some examples of that, but in a confidential session, I'm confident we could have shared with you even more examples where there were physical changes to design program, tracks or locations of works arising out of that design consultation through the process. And the ongoing consultation heading goes to the reminder that the committee will be aware that it's not just the consultation through the EES that is engages. There's ongoing work through the Operation Environment Management Plans, through obviously the CHMPs, which are heavily overlap, as I'm instructed, as time went on, the overlap with field work and the like. They sort of, in some respects, become the same consultation process, but in many others, there was a lead up through prior to those, and there are some issues that are sometimes canvassed around design, not that aren't really CHMP issues. The seasonal watering plans, that means you heard from View on the second day that they also vet and check with traditional owners, and expect that Mallee CMA in this case has reported its obligations to have consulted in the proposals, but has an independent role in approving those plans. And then, of course, there are ongoing obligations through the Live in Murray project and the Indigenous Partnerships Program. Mr. Kellerman can answer any questions around those matters or others, but I'm keen to move it on. So, Member Kendall, that's what I would have walked you through on memo, and perhaps if there's any questions for Mr. Callum of clarification, that will be all I'll have to say about it.
Thank you, Mr. Townsend. And I'll just, we'll ask the committee if there are any questions for Mr. Kellerman. No. So we're right to continue. And thank you very much, Mr. Kellerman.
I appreciate that. If Mr. Kellerman can, thank you, Mr. Kellerman. You're excused, I take it from that. So
yes, thank you.
I appreciate that. And we got that done within half an hour, which is terrific. I'll come back to the submissions around that, because I think that in light of what we've just done, I might be able to do this exercise reasonably swiftly, and I'll keep an eye on the 11:30 break. Is that intended today, Member Kendall?
Yes, definitely. And I'll just, yes, so we are scheduled for 11:30. That would be great. Thank you.
So if I perhaps just take you to the introductory parts of the Part C submission, the primary submission filed yesterday. In paragraph 1, we've tried to give you an outline of what we sought to do in these. They are in the nature of reply submissions after hearing all the submissions. But as we said to you on day 1, we would try to manage the way we're presenting to you within themes that we presented in our Part B document, and we've done that here. Hopefully in between those two dates, hopefully between the Part A, Part B, and now this document, the committee is appreciating, we hope, that for our part, for Lower Murray Water and for us, we've seen our role as very much trying to assist you with information and respond to questions as we can and support information. And it's been a very pleasant hearing in the sense that both we haven't wanted to be adversarial anyway, but also circumstances haven't really required us to be too much along the way. But I did want to stress that that it seemed to me, and hopefully the committee is assisted by not just having the lawyers' voices, but showing you faces of people within the organisations, so that you can get a grassroots understanding of the projects and what's going on. Hopefully that's been of assistance. One aside I'd make is that I'm not a huge fan of online hearings as such, but you know, it just struck me then to have the opportunity to cross to Mr. Watson, who's in a meeting in Mildura, and just drop in and out is an opportunity as an example of one we've had in this case. And we hope that's been of assistance to you. So as we go through these comments, it's a little more of us trying to put the submissions now in a context of what we say, but without meaning any attack or disrespect in particular on others who've made their points. We do think that the case in submissions that you've heard over the last couple of weeks raises a couple of general propositions that I might just touch on now because it'll save me time through the submissions. But the first is, like any case in public projects, committees tend to hear the what I'll call the objector voice, and there's always a necessity to put that in the context of the sheer public information available around projects. But the nature of these proceedings really that it's more likely, it's not exclusive in this case, there's been both types of submissions, but it's more likely than not that the submissions are focused or stem from opposition positions, and that can colour the time spent in a hearing. Of course, when the committee deliberates, it looks at all the material, not just the submissions that might have a particular point of view. But it's very important in our submission that they always be kept in context against the projects, and not because they occupy a period of time or a period of hearing time, skew their relevance or pertinence to the broader issues to be considered. The second is that we were careful not to interrupt or to make too much of a point along the way about the scope of the terms of reference as they influence the committee's obligations around water policy versus these projects. We would say, and we do say in these submissions, it becomes very apparent that almost to a fault, in almost all cases, the submissions around the projects stem from, are related to, or are thinly disguised submissions concerned with SEDLAM and other water policy considerations, or what the MDBA should be doing with water in the Murray River, matters that are beyond the control of LMW or Mallee CMA, but matters which are expressly excluded from your scope in the terms of reference for, in our submission, very good reason. And it did seem to us that even putting aside Dr. Murdoch, who had a very discrete issue, which we'll come back to, but even in the balance of all the submissions, and particularly Mr. Fruit and the like, it's impossible to separate what's being said about these projects from philosophical or genuine and, you know, well-intended positions held about water policy. And it becomes necessary for the committee to place that lens or that magnifying glass very carefully on anything that's said to you where it is premised, or it has a premise, or it has an origin in a principle that you're not asked to advise about, and for good reason. And so it seemed to us when we came to prepare these closing submissions that very much of what you've heard is becomes a bit tangential on that very basis, that it is expressly linked or obviously linked to a preference that the river would flow at greater levels for greater periods and with greater flooding, but of course with implications not mentioned to private land upstream, and not mention that they're matters totally out of the control of these projects and outside the scope of your terms of reference. And it is necessary for the committee not to, in our submission, cherry pick too much behind that. Oh, but here was a good point, or that's a good point. I don't mean to discourage that, that if you hear a good point, it's a good point. What I mean is that if it is a point that involves opinion, if it's a point that necessarily involves a judgment, and the opinion or the judgment is being expressed by someone who is very much focused on concerns about the water policy, then the judgment or opinion is of less value to you for the purposes even of cherry picking it out for these projects. And it does seem to us in hindsight that much of what you've heard is really an expression of concern about water policy put to you in the context of these projects and not the other way around. So that's, I've deliberately said that so I can sweep through as I go on. But it becomes a critical matter for your expertise as a committee when you're writing a report to, you get to judge, you get to discern, you get to listen to what someone's saying, but you get to see the context from which it stems. That's the one category that really goes to the water policy point. The second one, and again, I'll say this now so it saves me doing it expressly and taking up too much time, is, and perhaps overlaps with where the confusion might be coming from our friends in our cousin department, is that the process is not concerned with an approval under planning schemes. It is not concerned with using tools that we would need to get a permit. It is a wholesale policy project, which at the highest end is being submitted to your attention as an independent committee at the highest level to get a good policy outcome. And the whole reason we have proposals that are intended to be exempted from planning schemes or to be the subject of assessments by expert committees such as this is because they don't or are not expected to fit the box, or they are of special state significance, or they will confer policy benefits that the government has deemed to be important ones. And so it is no accident, far from an accident, that these processes aren't simply an application requirements case, because that's what the planning schemes and the administration of planning schemes is for. But when we take significant projects and premise them by the minister saying, I'm considering exempting this from the planning scheme, it's implicit that there are special circumstances at play which are asking committees to look at it through the lens of policy outcomes and benefit at that level, not at compliance outcomes or meeting requirements of statutory provisions that would apply to applications. And again, I put that as a broad opening salvo because it's picked up through we'd say, with all due respect, even through the TRG process and through some of the questions, our friends are raising, there's a failure to grasp just what level this inquiry is actually at, and why your expertise is being called for, and why the minister wants that advice, because the minister is not asking you to be saddled with or encumbered by the planning scheme. The minister is asking you, by specific terms of reference, to tell the minister if this is a good policy outcome and a good idea, and using those specific questions. And if we don't have processes like that, we will simply have assessments under planning schemes that are framed for identifiable circumstances that fit the box, and certainly would apply to all private projects. But where you have a government project implementing policy, the planning schemes aren't designed for them. And so even the exemption, the best thing about the exemption, we come to it, is it's a clue that even under the planning scheme, there's recognition that sometimes things don't fit, even under the planning scheme. But that doesn't mean that it should even be considered particularly pertinent to an advisory committee process with specific advice under the EES Act aimed at state policy outcomes. We're saying this is significant, let's get some advice about it. So I say that as the opening salvo because it would be, in our submission, unduly administrative for a committee to treat it like a permit application process, or you could have got a permit for this or not. That's not the questions that are asked in your terms of reference, and nor would they be. The difference is, how do we prepare information to assist you? And one of those, in this case, using the conservation works exemption, is within the performance criterion, what would an application look like? But they're tools. They're not ends, they're tools. They're ways of testing, producing information for you. But ultimately, you're being asked to assess these projects at a policy level, and to get acceptable outcomes unencumbered in any way by a statutory requirement that might apply to a private planning project under a planning scheme. And that's my second core point, because in those two, it would be our submission to you that we capture our response in many ways to the submissions. So in the written submission, we have adopted a general approach that we set out at paragraph 5, where I've introduced the document, and then we wanted to make some submissions to you around benefits and around the traditional owner values, and then really delving more into discrete and more pertinent questions around aspects of the projects, and leading then into some particular responses to that through the documentation. And that's when Mr. Forrester gets there this afternoon. But that point, if I can just pause, is worth an opening remark from me. The reason in these hearings it's good practice in our submission to prepare draft documents is as a working basis for the committee. The committee is not in any way constrained by the incorporated document as drafted, the EDSs. You are to provide your advice, But of course, we give you those documents and work on them and produce them in the hope that they are favourable in the way they're assessed by the committee, but they don't constrain you in your recommendations. And that's particularly so with the drafting of the incorporated document I touched on the first day. We saw our role as to bring to you a day one version of the document that was consistent with the evolution of that document, but not necessarily matching what we'd say is the best law or best environmental outcome or best process that would emerge under that document. So when you get to documents later, the main change you'll see is that we've removed the references to kicking the can down the road, as it were, on the question of offsets, because what we've submitted to you through the process, having heard from the specialist assessments, the reports on ecology and the like, and the submissions we'll make to you, and using the tool that we were asked to by DECA that Ms. Chapman will take you to, that that in many ways you should be satisfied. It's just not appropriate to, or it's not necessary in this project to be looking at a further cost burden or whatever it might be, or complication over above achieving the ecological benefits within the project area. But secondly, that it is also not appropriate where there's been an advisory committee process with a term of reference asking, is it acceptable to simply have an incorporated document that would leave that decision for another day. So the incorporated document as we've produced it is intended to match now what we'd say are our submissions, as opposed to the day one version, which was to, if you like, hold a neutral position pending the consideration by the committee of submissions by those submitters that you heard from. I think I've been clear enough this morning, Member Kendall, why the process in these matters is for interagency discussion to occur prior to exhibition. It occurred here, and we'd like to think that we've been very faithful about that point, that there is a judgment for the committee to make around the question of offsets. We've shown it to you effectively as an alternative in the day one version. It's not a matter for argument between agencies or for support from another agency. It's a matter now for the committee's deliberations, but we certainly discourage a kick the can down the road model and a firm incorporated document that gets these projects moving without further judgments, consents, or just a repeat of what we've had to do in this process. So I'm going to jump, Madam Chair, to, Member Kendall, to the reporting task section at page 3, simply by saying that we ask you to take that section as read in the light of what I've just said to you. When you go to the terms of reference, I know this is a matter that I do not need to dwell on, but you're aware that the Minister gives quite specific requests for reporting. And sometimes when you've heard the submissions and you reflect on those, you realise that there are matters that are not there that have otherwise occupied time. And that goes both to the degree to which the Minister wants you to address the Minister on matters of, for argument's sake, CHMPs, but also the specific reporting understood in the context of the exclusions within the terms of reference. So no doubt the committee will go to those matters, but obviously they ultimately define how you'll organise your report and your advice, and we're certainly keen to have assisted you in that regard. What I'd like to do with the 15 minutes is what I said I'd do, and go straight to the topic of that follows this morning on cultural values and the traditional owner engagement. And we deal with this starting at page 15 of the written submission. And if I can walk through this, that will be a convenient time, I think, Member Kendall. We've had to overlap here a bit with your terms of reference and the and some procedural issues, but also we go to the broader picture. The objective we've provided at paragraph 45 is of the project is to facilitate traditional owner aspirations for restoration of floodplain ecosystems by. It is implicit in the project objectives and emerging from policy and many years of engagement that the aspiration is for restoration of those ecosystems. You have not heard anyone contradict that, even in the submissions you had, which weren't really targeted to these projects, but the Mildrum submissions, there's no dispute around the aspiration for restoration of floodplain ecosystems as a matter of cultural heritage and an outcome that is desirable. And so the project objective is premised on that, and then seeks engagement and collaboration to integrate knowledge into the planning, delivery and evaluation of the project, and creating opportunities for enhancing and sharing cultural connections to country. For what it's worth, the project's confident that it's applied the personnel to, and particularly through the work with CMA and the inputs it gets from many other programs as described by Mr. Kellerman, to create a real body of work around that objective as forming these projects. And it's far from, as I think I submitted the other day, I don't think I've seen anything like this project for the sheer amount of engagement, not just for the purpose of conditions on a CHMP, but for an understanding of environmental watering programs generally, floodplain decline generally, and the what to do about it. And it's been unnecessary in my submission for that consultation to in any way need to undermine anybody's point of view that it would be closer or more akin to authentic cultural heritage outcomes to have a natural flowing river. That can go as a readily understood proposition, but the engagement and the aspirations I would submit to you have been very much around the what can we do, what can we do now, and not persons having to give up, if you like, rightful aspirations around sovereignty or ownership of water or naturalisation. And that is the experience of the projects, and it's what's happening at Mildura this week and Swan Hill last week. It's been happening for a long period of time. There has been dedication and input from those who can help with project delivery and conditions in CHMPs and ongoing input, notwithstanding that there are disappointments over the last 200 years of what's happened to the river. And so I hope that captures it from the project's point of view. And we hope that by today and in the committee's deliberations, there'll be no concern that hasn't been foremost in the delivery and the preparation of these projects, in the thinking of the projects. The scoping objective at 40, or the evaluation objective, is to avoid or minimise where avoidance is not possible adverse effects. And that's been a very fieldwork oriented program in part, but also an understanding of stories for reasons that are probably that the committee might be, I'm sure has an appreciation of without me having to go, and certainly not go beyond the line I'm entitled to go to. The fact that it's shared country is a significant factor, and it ought not be assumed by anyone outside the process or any other submitter that they speak for any one of these groups, let alone put them together as if there's one uniform voice. That's anathema to consultation and understanding shared country. And it helps explain, I think, for you, Member Kendall, why the public process is not the best place to be it might assist you in understanding that. So we point out that the assessment of the potential adverse effects of projects is in that specialist assessment. It probably should be noted, if it wasn't, the reminder I made this morning, that that's a redacted document in public for the same reasons we've been concerned about for the last couple of weeks in other respects. But that we've set out at 47 matters you've seen within the specialist assessment, and so far as the special assessment can set it out, what we'd say is a rigorous explanation, but also a comprehensive framework that you can see even through the preparation of the work that those consultants have been charged with, of delving into the necessary understanding of issues, including intangible matters that aren't just written out or reported, but where we ask the committee to take confidence that what you are hearing and what you can see both through the specialist assessment and through the broader consultation understanding is that there are no gaps or omissions in questions asked or lessons to be learnt. There are deliberate omissions in what's written down or reported or recorded, and there are matters of trust that must be firmly kept in mind in the lead up to this process and beyond. So the general outcomes of the assessment we've set out at 48, we say the consultations just furthered what I took you to in the objective. There is genuine goodwill and positivity around getting water onto country and not letting the ecosystems further decline, with an objective to return to a healthy state. And there is also an important outcome that consultation and learnings is an ongoing requirement, not for the preparation of CHMPs, but also for the further consent and approval process for operation. So there's no full stop in consultation, and that I think became clear also in what you heard this morning. So that comes out of the documents that are public. The term of reference that we with respect, say, I've said a few times, must be very sensitively managed by all the committees in these projects, is that it not be seen to be an edict or some requirement to participate. But read in hindsight, we'd say that, in fact, it's a term of reference that's best addressed at the end of the process, not as a preliminary matter to process, because it's with an understanding of everything that has happened that the committee, we'd say, can satisfy itself at the first part, any known views. We don't take the term of reference as requiring the committee to correct the work of traditional owners or be informed of the views. We see the committee as needing to be satisfied that the views are known. That's the point. You know, are the views known? Have efforts been made to make the views known without having to be expressly aware of every view, particularly in a topic like this. So the seeking of views really only matters then. And in our submission, in hindsight, the seeking was probably unnecessary in this case, if you're satisfied that the project has very much taken account and knows the views. But having said that, in this case, invitations went out. I'd make an aside for future learnings. I'd say that, with just as a gratuitous aside, but in my role, I think the first invitation concluded that the committee would be benefited by, and instead should have just been a mere invitation. It was probably an unnecessary stressor, because it makes it sound like people are expected to be there or the committee needs them to submit, instead of giving them an opportunity. So if that's something to note in the margin, or if it assists the committee, I would respectfully recommend that any future invitation be more of a neutral invitation than something that emphasises that the committee needs them to come, or because it might be interpreted as suggesting that they're disbenefit if you don't come, and that should never be the case. If I can put that as an aside, I don't think it's done. I'm not suggesting it's done any damage here. We just know through the process that this it's certainly been a matter that we're very much instructed is known to people that this opportunity is here, and there's had to be some management of that, and without people feeling stressed by that. So at 50, we go to that point that the committee really just has to make a judgment. The sentence in 50, a judgment is required as what might be reasonably needed to inform itself that the views have been considered and taken into account, is plagiarised a bit from a very welcome feedback from Member Ham the other day. I don't know if I've worded it well, but I, with respect, would support the approach that was taken in that proposition the other day, that the committee wants to have needs a reasonable level of satisfaction, and that's different from needing to audit, as it were, or be across everything. And if I'm not asking you, Member Ham, to confirm I got that right or wrong, but I just wanted to declare, if you like, that I've borrowed in part from that, and if I'm wrong about it, I expressly say now that I'm wrong about it. But if it is the point, that's one I'd say is correct, that there is a reasonable level of satisfaction from a committee's point of view. Yes, we're satisfied the work's been done and doing competently, and you should be very confident about letting a minister know that you haven't seen it as your role to delve into matters of confidence or beyond, or require people to tell you face to face. At 51, the realities in this case, there are several, and they're independent, and that's a very important point. There are independent traditional owner groups, and we have to be careful always not to, by using the expression traditional owners, assume that that is one group or one thought or one response, or that it's one response that applies to every piece of country. There are independent groups, but also, no doubt, within that, independent interests in independent areas within the projects. But they've been engaged, and it should be very clear to the committee they have chosen not to make a direct submission to the process. And we say at 52, the committee will be cognizant of the difference between consultation and the opportunity to participate in a hearing. They're not one and the same, and no project should ever have to prove by consultation that everyone who was consulted came along to the hearing and said they were consulted, or came along to the hearing and said they were satisfied. That's consultation is not as grand in its objectives as just getting everyone to agree, nor that it has to be proved by people appearing at the hearing. 53 I've touched on. 54, we point out there was a late submitter, but the majority of traditional owner groups consulted chose not to be here, even though, as you know, they're in meetings as we speak and last week with the very people who are in these proceedings. There is no lack of awareness of what's going on. So at 55, we say you've got no reason to doubt the level of interest or engagement, but the ongoing consultation occurs in a safe space, away from public airing, and where groups are afforded privacy on an individual basis and removed from any potential media coverage. It is a fact, you might have been aware, Member Kendall, there was a report on this matter on the first day in the papers, in the ABC, I think. And one of the reasons we were asking for confidential sessions was very much a concern that nothing I said or put or described might turn into some kind of a headline. So that's an important factor here. Based on questions from the committee, we've given a summary around consultation. I can just indicate to you, there's not a lot to add. There are 2 Jacobs attachments that were just an update. Really, they really are more of a recapture of the processes for the SIAC MPs, but they touch on they get up to the recent meetings, the Swan Hill and the Mildura. I won't take you to those. If that's all right with you, I can take them that you've received them. The closed session, we've dealt with that. I don't need to revisit any of those issues. I think at 60, there's another point on that I would just make about, we've got to be careful in our submission with any consultation for any Victorian that we don't get too singular for any particular group or owners in the context of the legislation, the right to participate. But I pointed out at 60 that it's a frequent experience in major infrastructure projects that in consultation, I'll give you a simple example, a landowner is going to be affected over the back fence. They negotiate with the project to have a 3-metre fence built and it's done. They're happy. It doesn't mean they have to then go to the hearing and tell the committee that they've resolved their issue. And so it's common for the consultation processes in public projects to avoid the need for community members to have to keep staying engaged or having to make submissions or having to turn up to hearings and take their own time out when they've been consulted and they're satisfied. That is the key point in any process, that people if the community is satisfied, we never have to drag them in to prove it. And part of the reason for being encouraged to get results in consultation is they don't have to get away from their day jobs or looking after the kids or whatever else they have to do, just because the process demands that they keep reminding us about what their response is or their attitude is. So it is a broader point in our submission than for all Victorians than just for traditional owners. That if the impression of the process is they know they've been engaged and they don't want to attend, that's important across the board. Now, so I'm not going to now read through 61 because I think they're matters well and truly traversed. And I've gone past my 11:30. I'm just going to show you our response to Mildren submissions is at the bottom of 20. And I think if I just walk through that, because that was the only relevant submitter, we'd say the committee ought not accept submissions on any matter, particularly aspirational ones. And with all due respect to Environment Victoria, I'd query the sensitivity or approach of assuming for these projects there are aspirations around the Treaties Act. There's a danger sometimes that in our interest, pro bono or otherwise, of lawyers to do the right thing, that got to be careful not to overreach if you're not representing groups. And if submissions aren't received by the committee through the owners, we would express some caution around applying views or conclusions or aspirations or interest in those issues through submissions from others who don't represent. And that avoids a patronising or in days of using language more gender-based, a paternalistic model in favour, which should be resisted against good consultation and listening, not telling and not assuming and not overreaching. And so we reject submissions made around this issue by anybody who is not representing or authorised to represent traditional owner views. As to the Mildren submission, which falls in a different category because it includes traditional owners, at 64, we've pointed out that, first of all, it became clear to us, and we don't make any, we think this is quite clarified. The committee might remember you got some emails from traditional owners around being included as signatories. With respect to Mildren and the process, we think there's an explanation for that that's a legitimate one. Mildren's submission with the signatories attached is not a submission to the EES or to these projects. It was simply provided as an attachment by Mildren. It was a document submitted by Mildren to Minister Neville, as she then was, in 2020 on the Sedland projects, a matter outside the scope of the terms of reference here. And I think when you look at their email, that's what I think they've told you as well. This is attached is a document that was. It wasn't prepared for this hearing. And so the signatories as they were then are probably faithful to a document as it was in 2020. But I think what you've seen from submissions is concern that it might have been taken or been confused with submissions around these projects. That's all. So I think there's an explanation for that, and the committee, when you go back to the email and you look at that document and understand what it addresses, and that it was written in 2020 and that it's not a submission filed in this EES, that might hopefully resolve that difference. But that's what we've explained for you at A and B. In fact, they're the same document. That document, there were two gentlemen appearing. And if you go back to the recording, it seemed to us there's a Mr. Mooney's emphasising that their main concern is water policy. There were broader assertions being made by Mr. Kennedy, but Mr. Kennedy in our submission, what he was saying about consultation or being invited to meetings, whatever, doesn't fit very neatly with what you've heard from the projects. But nonetheless, you've heard those submissions. We say there's no absence of opportunity. And if you listen to the tape, I think you'll find Mr. Kennedy makes the point that he is aware the Swan Hill meetings were happening at the same time. He said, oh, there's meetings happening somewhere else at the moment, as I understand it. As you've heard from Mr. Watson, there's no barrier to anyone attending those meetings. But we generally say that ultimately the Mildren position, without in any way criticising Mildren having views around water policy, is really around water policy and sovereignty in water of the like, and their legitimate positions, but ultimately not that informative for the committee of your satisfaction around the level of participation, engagement and ongoing work to be done in respect of the projects for those values. The other submissions point I've made, we say that traditional owners don't need to be spoken for by others. And then we've got RFI responses. I was going to invite the committee to take those as responses to RFI, and as with others, taken as a matter you can read. The committee was happy for me to let the RFIs be matters that you'll read. That would conclude that part of the presentation, and I'd invite you to take a break, and we'll come back to the vegetation framework and benefits section.
Thank you, Mr. Townsend. I'm happy to take those next response to RFI as read, but before we break, I'd just like to come to Member Ham and ask if he has any questions of you before, just noting that he's with us for the morning. So just to be sure we don't miss the opportunity.
Thank you, Chair, but I have no questions for Mr. Townsend.
Thank you. All right. Well, given that, we will break now for 15 minutes. It's 11:40, so we'll come back at 11:55. Thank you very much. Thank you very much, everyone. Welcome back. Mr. Townsend, I'm happy to hand directly to you to continue. Thanks. Oh, I can't hear you, Mr. Townsend.
Sorry, I appreciate that, Member Kendall, and we've given used the break also between Mr. Forrester and I, revisit a bit how we're going to make sure to keep our time frames for you. So there might be a slight change in the sense that what we're now intending, it makes more sense, frankly, is I'm going to take you through our discussion of the benefits and cross over to the attachment to the Part C, but also deal with Ms. Chapman. I'll then have some things to say by way of introduction around the broader environment effects, but rather than read you through the balance of the submission there, and we know the committee will have and will read it again, Mr. Forrest is able to take you the discrete matters that we wanted to do through the technical notes by reference to some of those paragraphs. So instead of duplicating that, if the committee is happy for us to leave a substantive part of this submission as read by you, we'll cherry pick and take you to things we need to do. So that's a slight change. Yeah, slight change what I said this morning, but gives us more confidence around timeframes. So thank you very much. So at our page 6 of the submission that was prepared for today, the Part C's, the heading benefit. And it's the first point in the written submission that we pick up the key themes we had at day one and introduce them as our thematic response in our Part C submission. And we consolidate there two of those themes for the purposes of under this heading. And the first of those, in hindsight, we say stands true, that the default assumption that the committee should be proceeding on the basis here that the opportunity for environmental watering of these locations that have been identified as floodplains is beneficial and at the very least an acceptable outcome. Now, we accept that leaves open the how, you know, making sure operations are responsible, but we would say that there can't be any reasonable opening to attack or subtract from the default assumption that policy says do this, water these areas. It's not going to happen sufficiently naturally, and you're not being asked to look at alternatives, which in any case we say you were, are not realistic. So that's number one, and the at least acceptable in that theme is important as well. You're being asked to advise in the standard test of acceptability, which the Supreme Court has described and is commonly applied in these projects as a threshold acceptability that understands that we don't have perfect answers, certainty, or that it's even necessarily the best ideal possibility. So the notion of acceptability is interpreted for these hearings is a balancing of pros and cons, as it were, and an understanding that what is proposed is acceptable in terms of outcomes, even if we could conceive of something even better, and even if the judgment around acceptability requires some understanding that within that balance there are expectations that need to emerge following the approval for that to be the case. And so we've said at the very least acceptable here. We would wanted to say desirable, and we'd say there's a good argument for saying it's highly desirable. That's strong language in terms of these planning environment tests. And so we've said it's certainly acceptable, but at the very least acceptable. And the second of those themes goes to the link point about that acceptability or that default assumption being linked to the operation of the programs as resembling natural circumstances. And if I just pause there for a minute, that phrase, which I think occurs elsewhere, but we certainly borrowed or adopted, is an important one, and is one where, from a more ignorant and personal level, I've had an education about based on the actual real-time floods that have occurred, because it's where you get the appreciation of just how slow-moving waters are across the landscape. There's localised energy, but across a vast landscape, it's actually it's a slow train coming, and it's not what I might have more naively imagined, where there are sort of environmental thunder, lightning strikes and torrents and floods. In fact, the waters can be moving over otherwise quite docile or temperate or warm or clear conditions, and aren't rapid. And that's obviously subject to the localised managed areas around where there's a regulator or where a diffusion is occurring. But the operation to resemble natural circumstances in our submission is most linked to just the energy and the depths that might follow with that, and the planning that goes around that is what we meant. But if that is the case,
Mr. Townsend, apologies for interrupting. I'm just interested if you could help by advising the paragraph reference that you're talking
I'm
to.
sorry.
That's correct.
I'm sorry. I'm doing my thing where I'm still on I'm giving you an overview by reference to the actual theme. So I'm still in the second
Thank you.
italics on page 6, because these are the reasons we drafted these themes in the first place. And I was still on that. I'll go quite quickly through the balance.
Thank you.
I beg your pardon. But it's that resemble natural circumstances phrase that I was focusing on, because the second part of that theme is that when you come to a risk assessment and benefits assessment, in our submission, you have a special case when, if you accept that the premise is that the flows will be something like nature, that it must follow that the risks and benefits are something like nature too. And that's really the proposition. And we take it one step further in that if it's resembling nature, we'd be hard pressed to say it's not acceptable. Nature brings its consequences, but very hard in our submission to describe any of those consequences as undesirable or unacceptable if they are akin to a natural consequence. So in defining the benefits, coming to that heading, Madam Member Kendall, we say that 15 is correct. We did understand Dr. Kelly to resist the do nothing expression. The do nothing expression occurs throughout the ES and beforehand, and in policy and in public outside of this process. But the do nothing for this process and for this committee is just that, because it's not open to us or to this committee to venture into grander schemes or reversing history, and so or changing policy. So we say the committee ought confidently proceed on the basis that these projects are addressing a decline, and that delay or not doing them is the do nothing. And we stand by that expression. In the Part A submission, we gave you a quote we've extracted there from paragraph 12, which goes to the description we gave then about that sad fact of the existing conditions and the severity of ecological decline. That is the very premise of these projects. And I'm sure it's not lost on the committee that it is that the severity of the existing conditions that's driving these projects, regardless of the input that might follow around interesting potential occurrences that might happen with watering, the primary task is to get the water there. And that's hence this leads very much the adaptive management point too. That quote we've given you there points to the overtaking of floodplains by terrestrial species as a negative, and also the likelihood that those species will die when flooded. These matters are implicit in understanding the existing condition. They are not consequences of the projects. They are symptoms of severe existing ecological decline. And the other point we make here that we think's a critical point that helps when it gets, for example, to Dr. Murdoch will return to, the focus is on water and EVC and or vegetation health, in the expectation that these are good indicators for floodplain health. And in our submission, all the species, it seems to me, from what I can gather, terrestrial species, are all dependent on vegetation. And so the focus ought be in our submission on health of floodplain vegetation and what that means for habitat or changes to habitat is a consequence of a healthy floodplain vegetation rather than the reverse, which is to approach the project as looking at opportunistic species, indigenous or otherwise, as being somehow affected by that situation. So the environmental impacts in our Part A submission were summarised in our paragraph 13, and we've adopted it there, pointing out that there are other values. There's a full range of factors that are relevant here that have not been the focus, and I know are not in dispute, but the implications of the projects are not just immediate in the sense of benefiting and helping to reverse decline, but have flow-on effects and benefits for our community and for local economies and for all sorts of other users and activities in the area as well. So that broader context I've just taken you to, we say at 17, is not really seriously challenged. There are interesting questions, but ultimately they are, in our submission, matters of detail and interest within the delivery of the projects, but not questions that ought be in any way amounting to a challenge to the projects versus a do-nothing project, do-nothing scheme. And so in a lot of ways in our submission, while there's been valuable feedback, we do say the committee ought not be in any way distracted by the substantial importance of doing something and then accepting that there will be risks to be managed, consequences to be managed within the do something, rather than that those risks amount to in any way a challenge of the default assumption. So at 18, we've said in large part submissions in opposition haven't sought to disprove the benefits of the projects, rather they've contended there would be some alternative benefit delivered by an alternative to the project, or the consideration which would be outside your scope, or otherwise they pose questions or concerns depending on uncertainty associated with natural processes. Will vegetation which is suffering at the hands of altered hydrology benefit from a more natural inundation regime? Will the works needed to deliver water to floodplains in the absence of adequate natural flows enable environmental watering to better align with the ecological needs of the floodplains? And in accordance with Lower Murray Waters submissions in the course of the hearing, we say, well, yes. And it's important to appreciate the projects are being designed to provide flexibility, to establish circumstances which managers can both respond to changing future circumstances and implement principles of adaptive management. In those circumstances, uncertainty about the future is better understood as one basis on which the projects have been identified by policy as required and as beneficial, rather than the reason for postponing measures to prevent or minimise the extant threats of serious and irreversible harm to floodplain environments. One comment that was made, I think it might have been Mr. Frood, in a sort of in a nice turn of phrase and sort of in a casual way, but it was about, oh, you're lumping this infrastructure on the banks, and the suggestion being, well, you might not even need it or something like that if you had natural flows, etc. But if the risk we would submit in the do nothing versus do something is that we get culverts and regulators that turn out to be unnecessary because we can't predict exactly the weather patterns and the likelihood of any frequency of natural floods. If the worst thing that happens is they don't get used much, and we have interfered with the bank to have the opportunity to use them but not required them as much, that's a risk we'd say falls within acceptable risk, because the to have those is the immediate response to the do nothing. To have the opportunity to water, to have the ability to turn the tap on, is as important as the actual circumstance of that tap being turned on. And so the infrastructure in our submission is the immediate response. And if it's used less and not more, that's not a bad thing. And it's not a, in our submission, it doesn't mean that in hindsight they'd say that was not the right decision or was unnecessary. I think some on the committee, I might be being unfair to Member Kirsch about it, but I could be wrong, but I think I've touched on the desalination plant, and I had a feeling Mr. Kirsch might have been there, but I might be wrong. But, you know, there are many examples of projects for one reason or other that have in part a safety rationale, or in part a preparedness rationale. It's the same reason why we have armies. So it's not a criticism of the projects that climatic factors might mean we don't need them as much as we thought we did today. So at 21, we say submissions which argue the opposite, that the lack of full scientific certainty as to the precise response of the dynamic natural systems which stand to benefit from the project should be used as a reason for postponing or abandoning the projects, are arguing for the postponement or abandonment of measures to prevent or minimise threats of serious and irreversible threats of harm to the environment. And they fall foul of the precautionary principle. And we found that an ironic sort of submission, that when the very premise of the projects is a precaution, to be have it suggested that, oh, we need to know more before we invoke that precaution, because you need a precaution on a precaution. This is a project which could be described as invoking the precautionary principle, because you act, and there isn't scientific certainty in our submission that you ought wait for when you have scientific certainty around the declining conditions. The project benefits point we make at 22 is the one we made in opening, that hopefully in hindsight the committee will, in its own language and with its own skill, be able to describe better than the TRG process was able to do in my submission, to rise above these projects in therefore describing what the benefits are, what the purpose of the project is. And that's what I said on day one, and it was partly because of the natural consequences of sort of a scoping requirements TRG EES model, to look for risk and look for a discussion and look for points of view. The danger is that one gets removed from the primary role, and I wasn't frankly convinced that unless managed carefully, the EES assessment process is the best way to investigate benefits of a project that is wholly conceived to immediately invoke something that resembles nature to reverse known decline. And so in that respect, we've given you some points around that. These are getting a little tangential and the committee may not need to go there in the end, but because you have a planning scheme role as well, we touched at 3.1 on principles of need. And in any planning approval, it is long established that your average planning permit, you don't need to prove need because you have the right to apply for something. But if you have need, that the need becomes a weighty factor if there's community need in supporting a planning approval. And the cases start with the helicopter Prince Alfred case, because there was such an overwhelming community need to do something that it became such a weighty factor that noise implications for residents in the area were overwhelmed by that. And this is a situation in our submission where the need is screaming out. And so that has to be very much factored in as this overall community benefit and the need to do it, without getting bogged down in too much legitimate but concerns that there might be other consequences or actions or impacts But if we don't tolerate those, we may not deliver the community need. So that's an important principle that we think can be carried over. But in another sense, it's just another way of saying what we've put through the acceptability argument and on the very facts of the ecology at stake. The second is that it's uncontroversial around the ecological decline. I would suggest Mr. Froude wasn't generous when Mr. Forrester put this, because it was one example where, rather than say straight out that these sort of projects can be very beneficial, the inclination would say, oh, but I've seen examples where it was done badly. That's not a genuine response. It's really trying to escape the common ground and the unarguable proposition that there is real potential for these projects to do good and to be ecologically very advantageous, and that, yes, you should look at management, you should look at operations, but you should not let those obfuscate an honest appraisal that these are positive initiatives, and particularly where the real objection to that is water policy. And so, with all due respect to Mr. Froude, he's a very knowledgeable person and deeply experienced, but in a lot of respects, we thought his submission and his response to questions was superficial. Not a strong engagement with the documents. In fact, I think he said he didn't need to. A high reliance on experiential responses to projects not done well, but declining to be really engaged in how this could be done well. And that, we'd say, is linked to a philosophy. Look, frankly, I don't think Mr. Froude should have, he either shouldn't have been in the expert elicitation or he shouldn't have been here, I don't know which, but the complications for Mr. Froude make it hard for the committee in our submission to treat Mr. Froude as something objective, impartial or scientific, rather that we have the benefit of an experienced person making some comments at a high level, but that need to be understood, and that they're not filtered through a reading of the EMF or the EDSs or the Inc doc or even the specialist assessments. At 23.3, we point the do nothing point, which I've made. So the National Park Association, again, and these are wonderful organisations and they play a very important role, and we would not expect someone resourced in the way they are or to make submissions has a thorough understanding of the EES or the specialist assessments. But we would have thought that there was overall a high degree of alignment between this project and the very fundamentals that underpin why the land is protected by the National Parks Act and why it is protected for the purposes of that act. And we would have thought that these are direct other ways of expressing the beneficial implications of the projects. So before the next point I'm going to do is get to Ms. Chaplin. But this involves going more directly to the metric. And I thought, if I might, Member Kendall, this is appropriate time just for you to cite the Monday document, which was the attachment to the Part C submission Victorian Native Vegetation Policy. I promise you I'm not going to read this, and I'm pleased that the committee asked for it early so that you could do so. And that certainly saves me time and effort. The starting point of this, of course, is that this document goes to matters at probably a depth that really responds, it seems to us, to an inappropriate attachment to clause 52.17. And so that's how we've responded to it. I'm not saying that by the committee, I'm saying that through the TRG process. I'm in no way criticising the committee for its exploration of these issues. That's what the committee's there for. But what I'm suggesting is that we've probably had to go to some of these matters because of a difference in approach or a difference in emphasis on the role that the statutory controls have, or the opinion of some other statutory person would have, or may not have, instead of a square focus on the terms of reference and the scoping requirements as informing that exercise. It's really because of that it seems now, in hindsight, the committee can see clearly, hopefully, that the whole how do we deal with the 5217 approach started the approach through the EES around, and the consultation approach around, the measurement of gain as a metric. Can you prove it as a metric? And we'd pause there and say that that's an interesting and analogous and valuable exercise, but it's not. It's a tool. It's not the intention of these terms of reference. It's not the intention of these projects that they fall under some metric. But secondly, it can be seen then that the expert elicitation, the request for the expert elicitation process then emerged. It seems a bit circular, but somehow Mr. Froude's work's involved and a submission, and those who are saying, oh, there should be a metric to prove you don't need an offset, then come back saying, oh, there's coarsity or coarseness in the base information, we need expert elicitation. The proponent again cooperated, helped to facilitate, cooperate with whatever expert elicitation meant for this project. I would confess to still being a little unsure about that, because there's an enormous amount of data, and expert elicitation is sort of a workshop when there's an absence of data. But nonetheless, that process ensued, but all under this banner of somehow needing to satisfy someone that there was a metric, that there was a mathematical or a calculable assessment around benefit. So one of the things the committee in our submission ought to, at the end of this process, is really reflect on whether those types of considerations are requirements for you to be satisfied that these projects match policy and will help reverse decline, or whether they're tools to help you in an analogous way look at it through different lenses and different angles. The latter, we say, is unobjectionable. The former, we say, is a misreading of the process, and certainly a misreading of policy. As we say, the committee should find the significance of these projects as falling into a much grander approach to ecological protection and enhancement than a mere offset model. And so that's what sits behind these submissions, and they were formulated on the back of the discussion we had the other day. So what we set out in that submission leads to that conclusion, that we've taken you through broader policy. Well, our points at 3 might do this. We made overarching observations that the projects are consistent with and designed to achieve the objectives of Victorian biodiversity policy, which provide for the protection and enhancement of ecosystems. This is a top-down assessment. In other words, you are at the highest level in the state, giving advice at the highest level of the state to see whether a project will meet that policy imperative. You're not at VCAT being asked whether, in a decision that would otherwise be capable of review somewhere else, whether it fits a particular test. That's not the question you're being asked. And so at 3.2, the draft PSA, the planning scheme amendment, proposed to operate such a clause 5217 will not apply to the projects, and therefore the conservation works exemption is not directly relevant. But we say here the policy rationale for that exemption is consistent with the project's intention of overall improvements to biodiversity. They mightn't be expressed as the same test, but the mere inclusion of an exemption in the planning scheme is this flashing light, even under planning scheme processes, to say, don't use this control to prevent projects with overall biodiversity gain. They might not need to provide offsets. It's an opportunity to treat projects that don't fit within the box. And that's consistent with exactly what the Minister's asking you here. Is this a project that doesn't fit through, you know, that stacks up without going down that process? But having said both those things, the proponent did do the metric assessment for analogy, did do responses to say, okay, if you want to measure it, how about this tool or that tool? And that's what is in the materials. And doing that's a challenge. I can't explain it myself. Ms. Chapman's coming to help me with that. But it's had to be done in a way that if you're going to use a tool, you've got to use it in a way that it would be used in Victoria, not just for these projects. So there's a challenge in what data do you put in? What point in time are you meant to be measuring? How would this be done for another project? How do you make it a consistent tool so it can be compared? So it is to be understood immediately as an exercise, a calculus. It's not a real thing. It's a way of trying to collect evidence or a line of evidence to help to measure or provide a calculus or support an answer. And we'll show you that in a minute, but the reality is it shows benefit anyway. It shows very strong benefits doing it. So we get to have our cake and eat it too, if you like, and say we can demonstrate, we can find tools that try to measure the benefit, but that's all subject to our primary submission that these should only be seen as tools or ways of trying to measure something, and they can become artificial against the state policy objective that is really the premise of these projects, and the scientific assessment of the decline that is immediate, that is really at the base of these projects, and the rationale for the projects that water is what's needed and we have to get it there. And that with that, you'll get an uptake in health. And so the project, LMW and our agencies from the TRG through to now have been trying to impress that bigger picture response, that policy response to the issue, over getting caught up in the mechanics of a test or a planning scheme mechanism or tool that is not perfectly designed for a project like this in the first place. And there's a danger you get caught up in and it becomes an ends, not a means. And that's been a discussion, I can say, committee, that goes back now a couple of years. And it might be that that's being echoed when I think about it in even questions arising this morning from our friends, you know, that there might be some officers who haven't got a grasp of the questions we say the committee has to have a grasp of. It's quite possible that's the situation. The most important thing is the committee gets it right. And in our submission, you therefore don't get in it. It's not a tick the box on someone having got the calculator out on a measure. Now, I don't want to in any way say it's not a useful tool. It is, but we're the first to say there's a level of academic input in these things, as with what we understand to be any benefit you'd add from the elicitation process. So with the introduction to that, Member Kendall, if it's all right with you, I'm going to reserve the opportunity, if there's time later, to potentially come back to that submission, as I will with the balance, but get on with the day. I've got 12:30 now, so my intention was to get Ms. Chapman to help me next with that presentation.
Thank you, that would be great.
And this is really, if I take you back to today, paragraph 25 is where I'm up to.
Thank you, and welcome to Ms. Chapman.
And there she is, thanks. So Ms. Chapman, thank you for being here for me, first of all, because you're here to explain and answer any questions or clarification around the exercise that form part of the work in response and through the EES process. So I'm going to introduce you so the committee understands what that role was and who you are. So can you just tell us what your name is and what your role is and what your role's been associated with the preparation of the EES?
Yeah, so I'm Hilary Chapman. I'm a freelance environmental consultant working with ARIP, who are technical advisors to VMFRP. and working with the ARAP team and more broadly across the team, sort of led the approach to putting together the overall improvement for biodiversity appendices that you see in the EES submission.
Thank you. And you were tasked, you're going to show us through some slides you presented, but it was your job to come up with a response, as it were, to the calculation of overall biodiversity or benefits, and to try to come up with tools or inputs to put that into a calculus, if I can use my language. And is that right?
Yeah, that's correct. Yeah.
And I know you have your own thoughts around why you would do it that way, but you were asked to do it nonetheless. So,
yes, correct.
Yeah, I might invite you. Are you going to screen share those slides?
Yes, I can do that.
Can I just remember, Kendall, you've got about what is it, about a 10-minute walkthrough, would you say?
I'd say so. Yeah.
Yeah. All right. Well, look, I think I'll just let you do that. I might have something. I might interrupt you, but yeah. I think the best thing is you screen share and just walk us through the slide.
Give me a minute. You'll just see my background, and then I'll put the slide show up. I think that's the easiest. Right. Just give me 1 second. This should work, hopefully.
Looks like a computer game.
Yeah, I know. I have a gaming computer.
All right.
Not a game. Yeah.
Okay, look, Ms. Chapman, just walk us through. And can I say, Member Kendall, obviously, if the committee just wanted to stop or ask questions on the way, Ms. Chapman's just here to help me explain the submission. So by all means, interrupt as you see fit if anything pops up. But
thank you, Mr. Townsend. We'll try and hold our questions till the end if we have any. Thank you.
Thanks very much. Off you go, Ms. Chapman.
Thank you. So the TRG requested VMFRP to prepare a submission which was overall improvement to biodiversity, which through much discussion ended up as appendices. And the DELT Native Vegetation Regulation Unit, which is now DECA, but if I refer to it as DELT, please forgive me, provided guidance on what to address. And I've summarised it, or I've set out what they said there, which is basically a comparison assessment showing that biodiversity losses will be outweighed by expected improvements to biodiversity, and that we needed to include an estimate of the losses to biodiversity due to the removal of native vegetation specifically, and an estimate of improvements to biodiversity, including expected improvement to native vegetation condition and extent, outcomes for rare and threatened species, ecosystem function, and improvements that will flow from this to biodiversity. And we have addressed that, and you'll see when I go through it that we've actually done it in a very slightly different order because it just made a little bit more sense to do that. I'd just like to give some context that, floodplains are, they're complex systems, as I think you've heard. I haven't got sat through all the days, but I know that the submissions, the EES talks about sort of all of the complexities of it. And they're dynamic, and they have an interaction of hydrology and ecology. And then on top of that, we've got multiple potential future climate scenarios, particularly with the stress test work that's been done by the MDBA. With the ecology, we've got many different aspects of ecology, and those benefits may occur over years to decades. So it's very hard to pick, a specific point in time. And in addition, we've also got, adaptive management, because we don't necessarily know exactly what the future is. And so there's a whole process that Victoria has around adaptive management. And then this project itself will have EDSs that look at, how these things are monitored, evaluated, reported, and also, and as a consequence of that, change. So there's a lot of moving parts to it. And then sitting next to that, we've then got the regulatory assessment and approval frameworks, which, I've described them, I guess, as static. We're trying to put things into, that complexity into a box. And I think, as Mr. Townsend said, these tools are not designed to assess these very large scale projects that, we've got, many hectares that we're trying to assess, and even to do the field work for that, has been a significant challenge. And also, those regulatory tools are largely designed to look at projects that are, removing native vegetation in order to put some kind of infrastructure in place or some kind of development. And so they're not, those tools, didn't have in mind, primary purpose being ecological restoration. So with the overall improvement for biodiversity, I guess our main approach was to be consistent with established regulatory assessment processes, even if we had to modify them a bit, and even if they're still not perfect, to really, so that it's recognizable, so that there's some understanding of what we've done and how we've approached it, rather than go off and invent some other way of doing it. We've used the operational scenarios that are in the project descriptions, and we've tried to use multiple lines of evidence, with bearing in mind those criteria that DELP asked us, now DECA, asked us to look at. In terms of primary inputs, we drew on the relevant EES specialist assessments, because we're in the context of the EES, and so it's not a separate piece of work. It's, I often describe it as a synthesis of everything that's been going on, and we had access to the specialists and we asked them questions, talked to them, as we were going through this work. It's also, we tried as much as possible to do a conservative, as in, not claiming benefits that are not necessarily there. So to err on the side of caution, I guess. And so for that reason, we excluded the construction footprint from the assessment of on the benefit side of the equation. And we also took out, it's not such an issue for Balsa and Hatter, but we took out any private land. So they're not included, tracks, they're not included, those sorts of things. So we've tried to sort of be, so when you see that the numbers for land are perhaps a bit smaller than the whole project, that's the reason that we've taken out, all those components of the physical landscape. So we've got up the top there so bear with me, it might be a little bit complicated, but I will try and keep it understandable. I haven't had to explain this in public too much, so please let me know if you have any questions. So we've got the project objectives, which are to better align the frequency, duration and timing of managed inundation with the ecological needs, and improve resilience to threats such as climate change, and protect and restore floodplain ecosystem values, etc. And so what we've done with the overall improvement for biodiversity is to look at, well, does the VMFRP frequency actually better align to the frequency and duration that would have been in place prior to river regulation? We've used that as our reference point, and I'll talk about that in just a second. That we look at the area of managed inundation, excluding those components that I've just mentioned, and that we look at the depth of the managed inundation. I'm not going to talk in here about the depth, because basically the depth of managed inundation isn't different from natural, from what would occur without VMFRP in place, or what currently occurs. We've also looked at we were provided with the climate change stress test, and so we've done the analysis of that, I guess, is a little bit more descriptive. And then we've looked at, and this is where we've put it in a slightly different order from what DELP gave us. We felt that looking at ecosystem function, and that's basically a description, that made more sense to go first, because that comes, the impacts on and benefits to threatened species and native vegetation kind of comes out of that. So that's what we've stepped through in the document. I think there's like 10 chapters in the documents, and starts off with method. Then it looks at this better alignment, includes a bit of look at the stress test, and then steps through, I think in 6, 7 and 8, if I've got it right, the ecosystem function. 7 is threatened species, and then 8 is the native vegetation. That NSIM NVR tool is the tool that is used for all projects in Victoria when the removal of native vegetation is assessed for offsets, and so that's what we've used there to try and be as consistent as possible with what occurs elsewhere in the state. So our reference point for better alignment Even though we're not actually, as a whole project, we're not aiming to get back to what was before any river regulation, but we've used it as a reference point for assessing better alignment. So that's frequency, duration, timing, and to some extent interval as well. So in that, we've looked at that for better alignment with the ecological needs of the floodplain. We also, as an additional line of evidence, as an additional, thing to see if we're, on track, was the document which the 2016 guidelines on water regime, salinity ranges, and bioregional conservation status, which we commonly internally known as the Fruit and Pappas document, and that has some ranges in it for frequency and duration of watering for various water-dependent EVCs, wetland-dependent EVCs. But our primary look is at the using the pre-regulation water regime that came through the business cases and uses the MDBA modelling as its basis. So I'm going to hopefully not baffle you with some tables here, and these are all in the, I've put the reference down the bottom here so that you can see the, sorry, I'm using the pen here. Sorry, just excuse me, sorry for the red. I'll just put the reference down to all the pages down there so that you can see them and follow along at your leisure. This is a table in section 5, which talks about the better alignment. And I might just use my pointer, apologies, that is red. This is the modelling on what the frequency, and we used 10 years because 10 years is what's in the NSIM regulatory tool. Pre-regulation, then what would occur with the basin plan with VMFRP, what would occur with the basin plan without VMFRP, and what occurs in the regulated river. And then we've got exactly the same median watering event, and this is the same but for duration rather than frequency. And so, for example, if we look at this lignum shrubland, sort of random, under the regulated river, that threshold of 50,000 megalitres a day would occur 3.9 years in 10. Under the basin plan, it would occur 4.6 years in 10. And under basin plan with VMFRP, it would occur 7 years in 10. And pre-regulation was 7.3 years in 10. So what we're looking at here is, does the basin plan with VMFRP better align to what would have occurred under pre-regulation? And then we've done basically the same exercise. You can see this similarly for duration. This is in months. And then we've given an indication of how many additional watering events would VMFRP likely have to provide. And of course, that's not an absolute because it's going to depend on what occurs in the future. It may be more, it may be less. And that's exactly the same, but just for Hatter. And then with the climate change stress test, there's, I think, 7 scenarios that came out of that. Some are wetter, some are drier. And when you look particularly at the dry scenarios, the dry future climate change scenarios, basically the conclusion that we've put in the overall improvement for biodiversity is that the projects provide more resilience to climate change scenarios, particularly to the dry climate scenarios, because you've then got, this is written in a very negative, I'm explaining it positively, but it's written the opposite way around in here. That basically you have the infrastructure immediately available to you in those circumstances. You don't need to go through the government process of seeking funding to get the temporary capability to pump water into the floodplain. And then each document, this is very small and I'm not intending for you to read it. I'm just trying to give you a little bit of an indication as to how it fits in the overall improvement documents. But there's a summary, which is table 8, I think, in both documents, which just sort of talks about is it better aligned or not in terms of frequency and duration. And we've also in there looked at depth as to how much of the EBC receives water at its maximum sustained preferred inundation depth. And out of the 2016 DELP guidelines, the Fruit and Pappas guidelines, that's the piece of information that we have used from that documentation to really look at what depth is required for, what depth do they prefer. And for the frequency and duration, we've relied more on the modelling. And so if these ones are all, actually there's one that's no, but we have taken this into account where we've looked at the benefits. So if there was a particular EVC that didn't necessarily, wasn't necessarily better aligned, we haven't considered that in the when we get into the native vegetation tool. And that's just, again, the same, but just for Hatter. So if I take you back, we've just gone through column 1 and column 2 of that flowchart, and we're now into column 3. This is the ecosystem function approach, and what we tried to do as much as possible was to ground our description of ecosystem function in regulatory tools again. And so we went back and looked at the MDBA's basin-wide environmental watering strategy, which has this very nice little diagram in it, which talks about flows and connectivity at the heart, how that impacts on biophysical processes, how it impacts on life cycle and biotic processes. And we've used that as our framework for describing ecosystem function. And we also needed to come back and look at ecological objectives. Now, all of those are still working. There's some of this stuff at sort of state and level and through the basin plan still in draft. And so what we used was the 24 objectives set out in DELP's long-term watering plan. There's a nice table that sets out the objectives. And then with the environmental watering management plans, as they get developed, they all respond to each of those criteria for the objective. So we thought that was a good way to do it, because it has some continuity through into the way that Victoria manages its environmental watering approach. So moving on to the second bar down, so onto the impacts and benefits to threatened species. We, in discussion with DELP, they asked us to use the habitat importance maps. These are a set of maps that have been prepared by the state government, which is a model data series that looks at suitable habitat within the current extent of native vegetation for each species. So it's sort of predictive. It says what it expects to be where, and and how valuable is the habitat that's present there likely to be for those species. And we've used that to illustrate threatened species and how important that habitat is likely to be for those species, both within the construction footprint and in the inundation area. And of course, the construction footprints are much smaller than the inundation areas. And so I've just got a couple of charts to show you, and I'll talk you through what these means. I know, again, these are very small, but they are in the documents. So along here, this isn't looking at importance of the habitat. This is looking at presence or likely presence of the habitat as modeled by DELP. And so along the bottom, we've got the potential impact in the construction footprint with the prediction of whether the species are likely to be there or not. And then on the y-axis, this is the potential benefit within the maximum inundation area. And this 45-degree line is just a 1-for-1. So, there's 1 hectare for one particular species in the construction footprint versus 1 hectare in the maximum inundation area. We just picked 1-for-1. As you can see, we could pick, you could pick any slope that you'd like. You can see that quite clearly from this chart that the benefits in terms of presence of habitat is much greater in the maximum inundation area than it is in the construction footprint. You can't see because it's sort of down here at the very bottom, but for there, and we've described it in the report, for Balsia there are 3 species where, just according to this, there's the potential impact in terms of this prediction in the construction footprint is slightly larger than it is in the maximum inundation area. And for Hatter, there's 1 species, and for each of those we've gone back and talked to the specialists and looked at their specialist reports and identified that either that species is actually very unlikely to be, in practice, to be in the footprint, or for example for the Murray River turtle in Balsia, that it is overall going to benefit from improved habitat, and there are ways through in the EDSs to avoid impacts to its nesting habitat. So where there's specifics, we've gone into those in the reports. And this is just, we were asked to look at, a number of threatened species. So we've just got this for, because obviously there's about 200 in each, in these smaller floodplains. There's many more in Lindsay and Walpollo when we get to those ones at a later date in the year. But we've just looked at 20, and they're typically ones that are either a higher level of threat or for some reason are of interest in this floodplain. And this is where we have picked up the habitat importance score. So this one on the left is the most important. So what the model says, and this is not our model, it's the state's model, is in the top 10%, the next 25%, then the following 20%, and then sort of lower significance. 20%, I may have my numbers wrong there, but anyway, you can read 90 to 100, 75 to 90, etc. And we were also asked to say, what does the model say for the whole of Victoria? How much of that habitat is there in the whole of the state? And then this is how much of that habitat is there in the construction footprint of which particular habitat importance score versus what's in the maximum inundation area in terms of importance. And the left is, further to the left is more important. So you can see, again, these charts are saying, and I've just picked, one plant species, one animal species. There are more that you can read at your leisure in the overall improvement for biodiversity. And you can see again, there's a clear outweighing in those figures. And then this is really the summary. So I'm going to talk about that third part that's on the bottom of that flow chart that we had. So at the top, we've got what's the area that's going to receive improved inundation on public land, and what's the area that's potentially impacted. So that's the construction footprint. Remember that the inundation area doesn't include private land tracts, etc., those sorts of things. As part of the DELP NSIM, the offset process, you have to consider large trees. And so we've got and these are estimates, of course. We've got an estimate of the number potentially impacted versus those predicted to benefit. And then for the...
Just on the impact of what potentially impacted doesn't necessarily mean removed though, does it?
Correct, sorry. So it doesn't necessarily mean removed. It means it's in the construction footprint. It may be able to be avoided. It may be subject to, lopping, but will recover. So it's not necessarily that's the actual number that will be removed. And of course, there are quite a number of EDSs, environmental delivery standards, around that particular point. Thank you for that, Townsend. And then the threatened species. There's really 2 different ways of looking at it. The bottom one is the one I've just shown you, which is the habitat importance mapping, which is that 3 and that 1 that I mentioned earlier in terms of ones that are potentially impacted. And then when you run it through the state's NSIM MVR tool, where you run it through and you say how many species will be impacted by and to what extent by removal, we've just assumed complete removal, and compared to how many will be benefited through the gain in the inundation area. So this is the same tool run through in the same way that it's used for any project, any infrastructure project. The one difference I would say to it is that on the when you consider an offset area, so an area of you look at, for a typical project, you look at the areas that are going to be maintained, you know, what are the areas for improvement? There's like a scoring system. For this project, we have only considered one scoring factor, which is there's a small number of points that are available for flooding for ecological restoration purposes. And so that's the only score that we've considered. We haven't considered any other, you know, potential methods. So that has been modified, and we've explained that in the document how we've approached that. So we've only given ourselves, or the project's only given itself access to a potential 10% of the, you know, the total score that's available within that tool. And you can see that there's, you know, still quite a substantial, still a very substantial benefit compared to the gain when you use this tool, right? So in summary, this is again just maps from the website, which shows you the different coloured areas are the ecological watering regime classes within which the various EVCs sit. The orange is the tracks, and then this is just the information that I've just shown you on the same slide, just presented in a slightly different way. And then we've got the same for Hatter, so it's just a more visual summary of what I had in the table. And that's everything that I had to say. I'm not sure if I took 10 minutes or longer. So.
No, thanks, Ms. Chapman. That I could not have explained that, so thank you. Member Kendall, there might be questions.
We do have a few questions of clarification. I'll hand to Dr. Briscoe to start. Thank you.
Yeah, thank you, Ms. Chapman. I've got a couple of questions about some of your slides. The first one is slide 7. It's the one, the overall improvement for biodiversity, better alignment with pre-regulation. It shows Belsi-Unguera.
This one?
Yep, that's right. Just in terms of the scenarios, you've got the basin plan with the VMFRP and one of the basin plan scenarios.
Yes.
Hydrologically, are they different in terms of what they assume about the water being taken out for the SDL adjustment mechanism?
Yes, they would be, yes.
Yep. So can you elaborate on that? So what would the differences be?
So the basin plan has, so VMFRP has less water removed than for the basin plan, right? Because it's the 650 gigs that goes back, right? Because of the projects.
Yeah, and so that the VFMFP one does have the 650 gigs removed.
Correct.
Okay, thank you.
Yeah.
That's good. Just wanted to clarify that. On slide 10, you talk about overall improvement in biodiversity. In fact, even on this slide, do you equate the watering with improvement to biodiversity?
No, not at all. No.
No.
So it's part of but it's an input, right? Because you need to understand, first of all, is it better aligned? Sorry, I should clarify that. So the premise is, I've not phrased that well, just let me say that again. The premise is that if you're able to better align the frequency, duration, the water regime, you're able to better align it with what it would have received pre-regulation, then that is going to be of benefit and more aligned with what was there in the past. But the reason I said not at all is because it's not that alone. It's also with the other specialist assessments and all of the considerations that are gone. Otherwise, you would only need to do, oh, the water's better, therefore it's all better. And this is this is a tool. We haven't done this without, this is done with the context of, the terrestrial ecology, the aquatic ecology. This is kind of a synthesis of that, if you like.
That's right. So I'm trying to understand in this table what you've done beyond the hydrological assessment to come up with the numbers like the areas and percentages.
So this table is predominantly the hydrological component to it.
Right. And where do I find the other component?
So there is a description of ecosystem function.
Mm-hmm.
Okay, and how watering contributes to that, which is in section 6 in the documents.
Mm-hmm.
And then there's a summary for threatened species, which is in section 7.
Mm-hmm.
And then the sections moved around a little bit. It's either 8, 9, or 10. I think it's I think it might be 8. That has the outcomes of the regulatory tool.
Okay, so these tables that we're looking at are hydrological.
Correct.
And so in those, you say you used depth as a factor in considering those areas. How did you estimate depth? Did you base it on a flat water surface slope or a sloping water surface slope?
Well, that data came out from the surface water assessment that was done, and it's a slice.
Sorry. Okay. So it's yep. I understand that. Okay. Thank you. That were my questions.
Okay, thanks.
Thank you very much, Ms. Chapman. We don't have any other questions from the committee. Thank you.
Thank you, and thanks, Ms. Chapman, for going to that. Ms. Chapman, I think you're excused by that. I think, Ms. Chapman. So thanks very much.
Yeah, thank you very much for coming along.
Member Kendall, it's 1:04 to give you an update. What I was going to, the balance of what I needed to do that I would have done before lunch, but I need another 10 minutes and happy to do it as 10 minutes if you want to have a shorter lunch or something, was to take you through then our pages 10 to and over onto 11. And it's at that point at the heading monitoring evaluation, although I may come back to it after Mr. Forrester, that we would really be drawing your attention to moving forward to the assessment of effects. And that's where we talked about before. I'll hand to Mr. Forrester. If I need to come back to you later, I will.
Okay.
So
you were happy. I'm happy to continue for 10 minutes and then we'll have a slightly shorter lunch. Thank you.
Appreciate that. So I'm at the top of page 10 in the written document, and on the back of what Ms. Chapman's assessments hopefully assisted with, how there was a rationalisation and attempt to describe. We say in the course of the hearing, particular attention has been given to information presented in the ES in respect of operational scenarios and their relationship with particular EVCs and species, and in some cases, efforts to criticise the manner in which that information was developed in accordance with tools that had been developed by DELP or DECA and used as a matter of course across Victoria, and or the basis on which it's presented. Now, we'd say that was always, as we say in the footnote, unclear how much depth, if you like, in those criticisms could be matched to an understanding of the specialist assessments and the work in the EES, or how much of it might have been experiential or broadside. But these matters will be addressed as relevant and are addressed, in each case through the written submission. But here we wanted to say there was noted that would be an error to proceed upon the basis that in order that any conclusion be reached, the effect that the projects are acceptable, the specific outcomes of enabling watering of floodplains in decline by reason of absence of watering must be precisely defined. And as we set out in the Part A submission, the consideration of responses of particular EVCs and species to watering are presented for the purpose of EES consideration of how the projects may be operated to achieve the objectives. targeting responses of particular EVCs or species will likely influence later environmental water decision-making as a matter for management or implementation. It's not a matter that goes to the overall benefits or of the need for the projects. It is a matter that informs the how, and there are plenty of steps for that post and approval. So designing the projects to maximise benefit, the projects conceived to maximise benefit while minimising impact. In this sense, the project design was unambiguously driven by achievement of the objectives with engineering design and ecological assessments and then proceeding hand in hand. In the most obvious sense, it's reflecting the manner in which the proposed works and infrastructure have been designed to provide for the greatest possible area of inundation, consistent with natural topography, but always with focus on minimising the need for works and infrastructure and minimising impact where they are proposed. This is complemented by the processes of avoidance and minimisation of environmental impacts, which is outlining part 4 of our part A submission and addressed throughout the evidence, and mainly Ms. Jelly describing design refinement as it affected vegetation. But moving forward, the proposed project controls attend to operation and management to maximise benefit and ensure impacts are avoided, minimised and managed within acceptable parameters. So, and can I just say on that, one thing that we would say the committee ought to be satisfied about whether it's in the level of design planning you've seen in the mapping or the descriptions through the special assessments, or even as a further, as that lens that Ms. Chapman took you through, is that there is a high level of exactness around the potential impacts. It's not minimised in the sense of the potential, it's measured as a potential impact, and it's down to potentially impacted trees or a very clear understanding of construction footprints and the like. So the committee's dealing with an estimate that is a comfortable estimate against which this understanding of avoidance, minimise and management through the design process can be understood. And while the project controls are properly understood as an inherent and critical aspect of what's proposed, no submitter, we say, has really engaged with the controls. We haven't got a lot of to do in the response to those. It's more questions coming from the committee than questions of anybody really rolling the sleeves up, it seems to us, on those. But on the other hand, it might be that it can be said that they're competently prepared. Now, there were 2 areas that we'll be focusing on around those documents, monitoring evaluation being one of them, and then, if you like, what we start with at paragraph 39, adaptive management understood in reliance on environmental watering and from experience through the adaptive management process. They both are touched upon through what Mr. Forrest is going to do, but they might be matters I'll come back to later if there's time. Rather than take time, Member Kendall, I just wanted to make a comment that emerges when we get back to monitoring, which is informed in part by some of the evidence or submissions we heard, and in particular the butterfly and Dr. Murdoch. The first thing we would like to say is I hope to think we did directly when we had the opportunity was to commend Dr. Murdoch for her commitment to ecological gain and conservation in the region. As a private landowner, that's no small thing, no small investment of time and commitment and passion. And we frankly thought that Dr. Murdoch was conscientious and honest and researched in the way she presented to this committee, and in no way is to be considered anyone other than is doing their best and has a real interest. And secondly, though, of course, so far as the private land's concerned, that's a property law matter and a matter that under the controls only becomes relevant to impacts on that land from environmental watering if the landowner consents to that happening. There was a reference by Dr. Murdoch to a document she saw being unsatisfactory or whatever, and that's fine. I don't even know what the document is, but it's not the point. The upper hand, the position of control is by and large the landowner, and so there's plenty of room for persuasion, discussion, etc. It seemed it's probably fair and in candid responses from Dr. Murdoch that there is also an acknowledgement that if it's part of the natural floodplain, natural watering is going to occur, as has in recent times, and with breaching of levees that might have otherwise been preventing lesser flows across that land. And it seemed to me quite responsibly, Dr. Murdoch had moved past any position, if she may have had one, that the land would not be inundated, to that it will be inundated. And so then it's a question of, well, what's the difference of impacts for a particular species from natural inundation or planned inundation? And the short answer would be nothing. So the question then really in our submission morphs into two propositions that come relevant to monitoring and evaluation. The first is, we'd say that the Agarus, along with other species, as I understand the research, including Dr. Murdoch's and others, is that it's vegetation dependent, it's habitat dependent. So its health depends on the opportunities that come with healthy vegetation, of course, particular species, the hot bush and the like, but nonetheless, it's dependent on healthy vegetation. And in that sense, in our submission is fits neatly with the notion that the indicators of floodplain health will be vegetation, and where there ought to be a little bit of relaxation around the mindset on what vegetation, or manipulating that too much on the floodplain, bearing in mind that it can be assumed those species will inhabit or seek out vegetation as it suits its needs. Secondly, we understood it to not be a common species, meaning not that it's rare or that makes it more endangered, but that it's not by nature a common species. It's a small family, not a large family. But we know that through this process, as a side benefit or otherwise, there's been further suitable habitat, and indeed sites discovered when they've been surveyed and looked for, both inside the inundation area and outside. And that's consistent with comments Mr. Holmes made, that it's not a well-surveyed species broader than those locations where those dedicated enthusiasts had been looking. And so it's evident through this process that the habitat options for the species are in some respects opportunistic within the floodplain, exist outside the MIA, but to the extent they do, are currently impacted, and lessons learned and adaptation from that can be seen in the future. So the point I wanted to raise, why it's relevant to monitoring and evaluation, is that our suggestion is that any attention to monitoring and evaluation is not too premised on hero species or species of interest, but more on value to measure floodplain health, bearing in mind there are always resource decisions and priorities to be made, and time and personnel commitments that what we would want to avoid by accidental drafting or otherwise is a position where a precondition emerged that might prevent timely watering, or equally unfavourably, where a decision's made in respect of one species that's not necessarily in the interests of the broader ecological systems in the area. And so we just say on the monitoring and evaluation and the principles that the floodplain ought to be considered more broadly than a focus on any particular species, and in particular one that might be a species that's benefited from 50 years of no inundation. So then that Dr. Murdoch shifted it then, well, what about other areas across the floodplain other than her land for that monitoring and evaluation? And we put that in the same category, that it's something that can be done. So we looked at as part of the broader ecology, but it's not something that should be given a hierarchical treatment or some kind of preconditioning or obligation in the sense of a response. But within that, you heard Mr. Holmes agree that for research purposes, there's an opportunity there to learn about a species, and there's a very real and evident opportunity to learn, to watch what happens where it's been inundated. And that's in itself a valuable proposition, and we don't shy away from it. Mr. Forrest will be coming back to the monitoring, evaluation, reporting points in the afternoon, and if I need to, I'll come back to that. So, Member Kendall, that was what we needed to do before your lunch break. And you'll have Mr. Forrester on screen when you come back. You'll see, I should have probably said this. When we get to the environmental effects of the projects, when you've read it from page 26, you'll have noted that there's kind of a formula we followed to pull out the evaluation objective, to go to the discussion and to give you some comment, on the evidence and what's come through the hearing. And we've done it in the overarching response of those themes I drew your attention to, and we'll draw your attention to those at page 26, so far as you've got that third and fourth theme around the proposition we advanced at the outset, that the work that's been done is thorough. There is a thorough basis. There's always further questions, always further research that can be done, but it doesn't get away from, in our submission, that there has been an enormous amount of research, both leading up to conclusions around the existing conditions and decline, but also through the EES, and that on the back of that you can be satisfied that the work that's been done on assessing risk is rigorous. So we don't put our submissions on the premise that there won't be further learning through adaptive management, but we also don't do that lightly in the sense of saying that that's a sufficient answer to having done thorough research. We say we've done both. And so that's the key point we make through the balance of those submissions. There will be particular paragraphs in there that Mr. Forrester will take you to, but will otherwise proceed on the basis that the committee's read in full the environmental effects section of the submission.
Thank you very much, Mr. Townsend. That approach works for us, and we certainly have read the materials, so happy for Mr. Forrester to take us through as relevant this afternoon. We'll have a 45-minute break for lunch, so we'll come back at 2:05 just to not cut us too short. Mr. Townsend, I'll just check that you're anticipating we'll be able to complete our submissions within the allocated time today.
Yes, we're as far as we're concerned, we're on track. Thanks very much.
Great, thank you very much.
Thank you for the short break. Yeah,
thank you. We'll see everybody at 2:05. Thank you. Thank you, everyone. Welcome back. Great, thank you. And before I hand back to you, Mr. Townsend and Mr. Forrester, I can see you have your microphone ready to go. I'd just like to acknowledge Member Ham has finished sitting with us for the day, so he's left at the end of our morning session, and also to acknowledge receipt of technical note 15 from the proponent that we have numbered document 184. So on that note, I'll hand directly to you, Mr. Forrester, for our afternoon.
Thanks, Madam Chair. Pardon me just 1 moment. Thanks, Madam Chair. I'm just sorting out our audio in here. Just sounds like we've got there. So thanks for noting the table document in respect of the TLM projects and the technical note 15. My intention is, consistently with what you heard from Mr. Townsend, to start by proceeding through and addressing you in respect of the matters set out in the Part C submission from page 26 and onwards in respect to the environmental effects of the projects. In doing that, I'm going to identify and occasionally talk to some of the technical notes in particular that have been filed and identify for the committee some of the other documents that have been filed, including yesterday. Ultimately, I'll step through those matters and then address you and walk you through that technical note 15 in respect of the TLM and Hatter Lakes TLM projects, so that the committee's up to date with it before we close. But after doing that will be the time when I move then on to the final day project documentation, which has been filed with the committee in the form of an updated incorporated document and updated environmental delivery standards and monitoring requirements, which in the latter context weren't in the day one version, but there have been a couple of changes to address things arising. When I'm talking through the particular environmental effects or the categories under the headings of the evaluation objectives, I'll take the opportunity to identify for the committee where changes have been made in the final day EDSs as we step through. I think that'll be more efficient than doing it all at once at the end, because the changes are pretty minor and directly relate to matters arising in evidence. Now, as the committee will have seen reading through the Part C, particularly in this section from page 26, what it does is set out the witnesses on whom LMW rely and the evidence that they've given in very high level terms on the basis that the committee has the record of the evidence they've given. And in that context, all of those experts have given specific consideration to both the question of impacts and risks assessed in the relevant specialist assessments, but also to the proposed EDSs and monitoring requirements, and subject to a couple of minor changes, have identified them as suitable, fit for purpose and effective to manage any relevant potential effects within acceptable parameters. I'm not going to repeat that statement as I speak about every witness, and indeed, as I step through, I'll do so at that high level to speak to what's in the Part C submission on the basis that the committee's received the evidence and has received, amongst other things, the EES and other documents that we've filed. So first then, to talk to aquatic ecology, which comes up at page 27. I'm moving past the floodplain restoration draft evaluation objective in the context of the committee having heard from Mr. Townsend today, with the assistance particularly of Ms. Chapman in respect of the implementation of environmental watering and the enhancements to function and biodiversity that will result in on the basis of the assessments set out in the EES. In respect of aquatic ecology, the committee received Mr. Marsden's evidence. Now, Mr. Marsden's participation was as a peer reviewer through the Berg and his membership of that body, and also with the insight and information he could provide as a member of the technical advisory group, which reviewed effectively and is still engaged in process of review in respect of project design, as well as specialist assessment aid. Through Mr. Marsden's expressed opinions in respect of what might be taken as obvious, in the sense that aquatic fauna will benefit from water being on the floodplains in both natural and managed circumstances of inundation. The project itself and the committee now have had the benefit of Mr. Marsden and his clear expertise in not only those matters that are addressed in the specialist assessment in the technical sense, but also the practicalities associated with monitoring, management and maximisation of benefits such as connectivity through design of structures, including fishways. That's assisted in an understanding that while there are direct similarities in this particular context between benefits accrued in circumstances of natural flooding and managed inundation, in many cases, potential adverse effects associated with inundation on aquatic fauna are able to be better managed in the context of managed inundation. And the project's been carefully designed to be providing for a framework for that to happen. Now, Mr. Marsden, as a peer reviewer in giving his evidence, was given some questions which were taken on notice and responded to in technical note 12, table document 165. I won't open that document and speak to it in detail, but the committee will have noted it addresses matters including the question of interaction between mitigation measures excuse me, which is perhaps a common theme across the various disciplines, but which is a matter to be resolved consistently with current practice of environmental management through careful application of adaptive management and careful management of floodplains. The other matter that I might identify in respect of Technical Note 12 is the specific identification of how the aquatic ecology specialist assessment had regard to natural flooding circumstances as compared with managed inundation, which R8 and Mr. Marsden have identified at section 7 of that technical note. The next matter, which appears at page 28 of the Part C submission, is terrestrial flora. This is a subject which, by reference to the attachment to the Part C that the committee's already heard some information, some submissions today, and indeed through Ms. Chapman's assistance. But in this respect, and leaving those submissions aside for the moment, the committee has received the evidence of Ms. Jelly that assisted in understanding the very substantial work, including survey efforts and application of other standard tools in specific ways for the purposes of the projects, which were undertaken. And the focus in particular on construction and then impacts through inundation, including the identification of the anticipated or predicted responses of particular vegetation. I'll note the specialist assessment and Ms. Jelly in her evidence also assisted in an understanding of those efforts put through project design to date and which are required to be put into the future in respect of avoidance and minimisation of future impacts. And the committee will now have a good understanding of the worst case basis on which that assessment proceeded in respect of particularly the quantum or area of native vegetation which might be considered to be removed, potentially removed. In noting that the assessment of Ms. Jelly's evidence will assist in the context of identifying anticipated or predicted responses, this was one area which was the subject of some criticism on the part of Mr. Frood. The committee will recall there were references in Mr. Frood's submission and evidence to the effect that the EES had or was deficient because it had failed to identify species which are not listed, which are common and which commonly occur across the floodplain and which indicate the health of the floodplain, but which, as far as Mr. Frood had seen, were not considered. The Part C submission sets out the manner in which species like those specifically identified by Mr. Frood were in fact considered for the purpose of the specialist assessment. Now these propositions weren't put to Ms. Jelly, but in any event, the committee will be able to take on the face of the documents the fact that insofar as this assessment has considered flora, while there's a obvious focus on listed species, or threatened species and otherwise, to answer the scoping requirements and to address the specific matters for the committee's reporting, there's also specific focus on the broad range of benefits that will attend the broad range of vegetation across the floodplain and which forms part of floodplain communities. Now, there's particular attention given, of course, in the context of the EPB SIAC to the winged peppercress, some difference between, well, represented by Mr. Frood's expressed opinions in respect of that particular species, which appear to have been informed by at best personal communication with others. We would urge the committee to consider the National Recovery Plan for that species, which is cited and referred to in the context of the documentation before it, which specifically identifies that it will benefit from that intermittent inundation that Ms. Jelly has referred to in identifying its predicted responses. The other matter which has come up a number of times in respect of terrestrial flora is the terrestrialisation question. And the committee's seen and will have regard to the information provided in Technical Note 8 in respect of terrestrialisation. It's table document 138. Now that document sets out in some detail factual information in respect of where this process of changes in composition of floristic communities has occurred and where it has effectively been reversed or addressed in the context of environmental watering. There's examples given of particular ways in which this terrestrialisation process is observed to occur, but also of the TLM Hatter Lakes site, the Gunbower Forest TLM site, and Long Swamp, as examples of places where environmental watering has been identified in the context of monitoring and evaluation as achieving benefits, because, amongst other things, it has provided for a closer alignment of how habitat is expressed and how communities are expressed at those wetlands with what would naturally have occurred before the relevant alterations to hydrology took place at those sites. I draw the particular attention of the committee to that because, again, in Mr. Froude's evidence, it received some assertions to the effect that adverse impacts had been experienced at places like Long Swamp. And the terrestrialisation technical note provides the specifics around that assertion of Mr. Froude, which, as I understand it, related to the leek orchid that exists down there in the southwest quarter of Victoria, and which basically is starting to find its way back to the habitat it should be in as the water has returned to closer to the natural inundation extent. The orchid persists and is developing in its fringing habitat in locations which are closer to those which would have naturally existed. Now, consistent with those examples having been identified in the context of the environmental watering framework as beneficial, the committee's heard the view of the proponent in respect of how terrestrialisation should be perceived and conceived of in the context of consideration of effects of the project, and the fact that in the view of the proponent, consistent with the policy supporting these projects, to the extent that terrestrialisation is reversed and floodplain habitat is restored, that's consistent with the purpose of these projects and and represents a beneficial outcome. Those submissions, I suppose, are supported in detail in that technical note 8, and I won't talk to them in further detail given the time that's been spent on them. And again, Ms. Jelly will have assisted the community in this respect. You heard also here some comments in the course of Dr. Murdoch's evidence in opposition to the view of the proponent, describing the conceptualisation of restoration of floodplain habitat by the reversal of terrestrialisation as anthropocentric, and simply I'll say in response to that in light of the fact that these processes have occurred as a realisation of threatening processes, including alteration of hydrology, while this might represent a simple difference of opinion or characterisation of the type that Mr. Townsend referred to earlier, it's one with which policy does not agree. Finally, in this respect, I'll note the comments provided at paragraphs 99 to 101 of the Part C submission. Again, you've heard from Mr. Townsend in respect of Mr. Froude as a witness, and the fact that in the proponent's submission, the committee should receive what was presented as his evidence very much as the evidence of an interested party who was not participating as consistently with the manner in which an independent expert should participate in processes like this. His philosophical difference obviously plainly informed his approach overall, but it was also the case that Mr. Froude was both not particularly direct or helpful in responses to questions, and that he had not adequately read the EES to a degree that would allow him to form the views that he was expressing to the committee. Now, the committee otherwise has the record of his evidence and its manner and content, and I'll commend those comments to it. In respect of Flora, finally, the committee also has technical note 13, table document 171, and that addresses another one of Mr. Froude's examples, the Avoca marshes, as well as identifying and correcting the ambiguity in some figures and tables which you, Dr. Briscoe, identified and spoke with Ms. Jelly about. And I hope that clarification assists the committee. And the next matter, if I can turn to page 31 of the Part C submission, is fauna or terrestrial fauna. in respect of which the committee had Mr. Holmes's evidence, as well as specialist assessment B, or the parts of it that relate to fauna and their interrelationships with the flora sections. The particular conclusions which we would invite the committee to draw from Mr. Holmes's evidence include that the assessment proceeds and his evidence proceeded on the basis of an appropriate consideration of impacts at potential impacts at a population and landscape scale in respect to potential habitat. And again, that the work done which led to that assessment was very substantial in respect of survey and investigative efforts, and reflects a very adequate basis upon which this process can proceed. In a similar vein to what I've just said about flora, the committee will again appreciate the benefits to flora which will result from efforts to address relevant threats and ecological decline. Again, responses to questions on notice are provided in Technical Note 13, table document 171. And on the basis of Mr. Holmes' evidence and the assessment and those responses, the committee can be satisfied that the projects will, in respect of this particular aspect of biodiversity, deliver overall benefits to fauna species, with impacts of any significance being avoided and minimised through design and mitigated through project controls as proposed. You've heard again from Mr. Townsend about the particular attention given to the Agarus, the butterfly, in the course of the process, and the fact that the proponent's primary consideration here is to ensure that focus on one species does not overwhelm or is not determinative of the benefits which might be delivered to other floodplain specific species, notwithstanding the fact that particular monitoring requirements are included in the final day documents. At this point, before moving off the ecology side of things, I'm just going to share on my screen the final day environmental delivery standards to identify the relevant changes which have been made. It's table document 177, and I'll just make it bigger for you. The first relevant change appears at page 8 of this document, and EDS E2D. And the committee will recall Mr. Marsden's recommendation that relevant requirements in respect of weeds and monitoring and investigation and management of weeds be clarified in the sense of relating to both terrestrial and aquatic weeds. So I hope the committee can see that on the screen. I appreciate it's still quite small. So that's been inserted into the construction weed and pest management requirement, which will require the native flora and fauna management subplan to include relevant requirements in respect of that issue. The next matter at page 23 of the document takes us to the table of monitoring requirements, which is table 18.13 from the EMF. And in this respect, the proponents included two requirements in respect of the Agarus. The first relates to the assessment of the impacts of the recent flood event on the butterfly by reference to surveys of recorded adult and oviposition sites within the maximum inundation area, and that be undertaken once prior to operation. The next new monitoring requirement, MTE11, is to assess the response of the Agarus over time to environmental watering, and again, requirements in respect of similar survey in respect of public land within the MAA, and then once operation commences every 5 years for at least 15 years, and then for the need for the ongoing monitoring to be reviewed thereafter, on the basis that by that point it will be apparent first whether the ongoing monitoring and evaluation is worthwhile, and second whether the response to the butterfly is such as to require ongoing monitoring in the sense of its response as being acceptable. Now, the final change is one which was not specifically recommended in itself, but it relates to the auditing and investigation requirement, AITE2, shown on page 28 of table document 177. This is a monitoring requirement in respect of weed and weed cover, and the committee will recall Ms. Jolly did recommend a change to EDS E2D in respect of, to put it in crude terms, vehicles, biosecurity as they enter and exit construction footprints and so on. This monitoring or auditing and investigation requirement has just been updated to ensure consistency with EDS E2D, such that it's not limited to those matters that have now been expanded upon by Ms. Jolly. I hope that explanation is clear enough, but you'll see on the right-hand side of this table, as with the EDS table, that there are comments recording these matters for the committee and explaining where changes have originated. Now, I'm going to return to the Part C submission in respect of matters related to water. And the first is surface water, which starts at page 32, paragraph 113. In this respect, the committee has the evidence of Dr. Treadwell, which will assist it in understanding potential surface water impacts, noting as set out in paragraphs 115 and 116 of the Part C that those effects are limited and largely consistent with, or improvements by comparison with, effects which would occur in natural floods. For example, the spectre of black water or low dissolved oxygen events, which occur as a matter of course in natural flood events, is an effect or risk which, by all expert accounts, will be diminished through the operation of projects to better align hydrology with natural circumstances. And so while it's one which is appropriately managed in accordance with the proposed project controls, it's one which Dr. Treadwell expressed confidence, as did I think Mr. Marsden, in respect of the beneficial aspects of this project. Similarly, Dr. Treadwell was unequivocal in his evidence in respect of outcomes in respect of salinity and salinity impacts, noting again these impacts would, consequences of flooding and raised water table would occur in natural flooding. These matters were addressed in the immediate context in terms particularly of salinity in Nagoya Creek, for example, but also further downstream, in respect of which the unequivocal position is salinity is predicted to be well below identified indicators in respect of all relevant beneficial uses and those established under the basin plan. And that was the case, the committee will recall, in the context of the worst case operation, the maximum inundation of all VMFRP sites considered cumulatively. The committee did receive submissions on exhibition and then before it in its hearing that adopted the pejorative terms of ponding or creation of irrigation bays and the like. And in this respect, it's important to come back to Dr. Treadwell's conclusion, which was not seriously challenged as the expert before the committee, to the effect that the hydrology of the floodplains will not be materially changed by the proposed works and infrastructure. And the committee has his comparisons produced in the context of the specialist assessment and then provided to it again in technical note 11 to the effect that the flood patterns in natural events and in inundation events, in natural events assuming the presence of the project infrastructure, are very similar. I've mentioned that technical note 11, and this is one I won't speak to in detail, save again to note that it provides some additional mapping and information which I trust will be of assistance to the committee. In the Part C submission, a couple of particular matters are addressed in the context of submissions which have been made about under the auspices of the surface water assessment, and certainly relevant to things done in that context, but also in respect to the projects more broadly. The first relates to the use for the purpose of the EES of the source Murray model. And before getting to what those criticisms were or the basis on which they were made, I'll just identify what that model is and where it's come from before how it's been used in the EES is set out. The first thing to note is that the source model is was developed and is used by the MDBA and a wide range of related authorities and persons to inform water resource management and water policy decisions. It's a model which is required by the Commonwealth Water Act and by particular legislative requirements of the Basin Plan. So they've been required from 2012 in terms of the specific requirements of the Basin Plan. And shortly after the Basin Plan was made, and there's reference in the Part A to 2013 implementation agreement for the Basin Plan. By that implementation agreement, the MDBA and the Basin States agreed to adopt SOURCE as the model to be used for future modelling and assessment purposes. SOURCE was initially developed from, I understand, the early 2000s, so for a very long time before it was before prototyping of it commenced in 2013. So its development was more than a decade worth of work, and from 2013 it has commenced to be implemented under the auspices of and within the context of the Basin Plan, but it has not remained a static model, contrary to some submissions which have been made. It has instead been a matter of and subject to ongoing development, which over the time since 2013 has been updated, amongst other things, for example, to include the Living Murray projects and to address other specific matters in respect of operation tools and so on. So it's not right to say it's a static document, or it's a static model, pardon me, more than a decade old. It uses, of course, the data which, as we've heard, and as a specialist assessment identifies, exists in a data set which ends in 2009. And it is a model which, as we have also heard, is subject to planned current processes of improvement. But it's important, as we've done in the Part C submission, to identify that it is a model which has been repeatedly and independently reviewed, independently of these projects and independently of any party interested in these projects, in the sense that at first we've identified in the Part C a independent peer review of it against its legislative requirements in the context of the particular context of calculation of diversion limits and the like, the context which is set out in the submission. And that was a review carried out by Professors Jakeman and Croak and Dr. Iwanaga of the Fenner School of Environment at ANU, and it concluded it was fit for purpose. And as we've set out in detail in a quote from that review, it's designed to be used for a range of purposes over time, including water resource planning, understanding of hydrological processes, legislative responsibilities and river operations. It is appropriate for these purposes and is largely extendable to support new policy and management initiatives. There's reference to its potential integration with groundwater models. And there's a note to the effect that there is a valuable cohort of people working with and around the modelling that facilitates ongoing progress and healthy discussion. So that was a peer review that's identified at footnote 47. I had to tick over the page to get there in the Part C submission. And that's published in early 2019. Then in September of last year, so September 2022, the Inspector General of Water Compliance, which is constituted, as the committee might recall, again from the Part A under the Commonwealth Water Act, the Inspector General of Water Compliance carried out what it describes as a robust review of the modelling used by the MDBA, and again concluded that the SOURCE model is fit for purpose in its current form. None of this is to say that improvements to it aren't desirable or won't be worth pursuing, as the MDBA, we understand, proposes to do. But that doesn't mean it's not presently fit for the purposes that the Inspector General of Water Compliance and that the independent peer review concluded, and it doesn't mean it's not fit for purpose for this EES. The other thing that we note in the Part C submission in this respect is an article which we've actually tabled. It's referred to and tabled as table document 176. It's referred to at footnote 48 in the context of paragraph 119 of the submission. which we thought important to bring to your attention because there's been some reference made to this article, which is a publication under the umbrella of the Wentworth Group of Concerned Scientists, as establishing this, what he describes as this discrepancy between expected or modelled flows and observed flows, including at Hatter Lakes North. The committee will be familiar with that reference. It's important to note, though, that it would be unfortunate and likely misleading to suggest that that is a conclusion which supports the assertion that that means there's something, or that's attributable to issues with the source model. As paragraph 119 sets out, that article certainly does say that there are issues it conceives of with the model. And while identifying quite fairly that any model is going to have uncertainties, it provides suggestions as to how it might be updated. But that article also, importantly, identifies a range of reasons for the discrepancy between what it describes as expected and observed flows. Now, to be quite clear, I'm not suggesting here in particular that this reference to this article represents any effort to mislead, just that the committee need to be careful about the manner in which it's taken and what it's said to represent. In particular, in that respect, I'd note, I think it's the case, my understanding of Professor Pittock and Dr. Colliff's submission is essentially that the model should be updated to reflect or to address or take account of those range of reasons for the discrepancies such that we can best use it for water planning into the future. And at least as they assert, the model will be updated for that reason. So while it will be improved into the future and those improvements will assist in future decision-making in respect of river management consistently with the purpose of the source model, again, that doesn't come back to an issue which can be attributed as, or which can be described as something fundamentally wrong with the surface water assessment. The other relevant matter that we've pulled out and addressed in the context of this surface water section is the constraints management strategy and proposed constraints relaxation projects under the basin plan. At the outset, we note again that insofar as submissions relate or referred to the constraints projects, constraints strategy as an alternative to the projects, that proposition is outside the scope of the committee's tasks and is also not an accurate understanding of or reflection of the manner in which policy conceives of and has been conceived to provide for projects like the projects before the committee and the constraints projects. We've previously submitted that the projects as proposed are something which ought to be considered and which are, as a matter of law and policy, complementary with constraints relaxation. And it's important to note in that context that the constraints relaxation projects and the constraints management strategy were conceived of and developed in the formal documentary sense at similar times. The committee's got the constraints management strategy from 2013 and will understand that in the context of the integration between the planning of these matters, again identified in the Part A submission through the Basin Officials Committee and as relevant to the Sustainable Diversion Limit Adjustment Mechanisms projects through another committee called the Sustainable Diversion Limit Adjustment Mechanism Implementation Committee. The primary governance forum by which all of these things have been or have found their way into the policy of the state and intergovernmental policy as it exists involved integrated and interrelated consideration. Now, the other thing to note is consistently with Mr. Sheehan's presentation at the outset of the hearing, many elements within the basin plan will ultimately change flow within these or this reach or within the river more broadly in ways which will enable and improve the way in which these works can be used. Those measures will include things like the Enhanced Environmental Water Delivery Project, which is referred to in Professor Pinnican and Dr. Cole's submission, and which is a SDL project. And they'll also include other rules changes, system enhancements, and so on. But it is not the case that they will replace or achieve the same outcomes as the projects as are proposed. First, that's because they won't achieve the necessary flow levels to achieve what the project's proposed to achieve. And this is reflected, for example, in there's reference to at paragraph 123 of the Part C submission in the likely flow levels or possible flow levels identified as resulting from constraints projects. And there's reference to the 70,000 megalitre a day figure, which by comparison with the 100 and 160 megalitres, 160,000 megalitres a day figures, which represent the equivalent flow thresholds associated with the operating scenarios presented in the EES, stand as an example of how, yes, it might be the case that constraints projects will enable smaller inundation events. And that's both consistent with the projects and a beneficial thing for perhaps not only these floodplains, but others or other channels and so on. But in those circumstances, first, the projects will operate in a better way, in the sense that they'll be able to piggyback on those higher flows as is proposed and described in the EES. Second, the projects will be able to take advantage of those higher flows to get water out to the floodplain, which will otherwise only be inundated in higher events. And third, the projects will still be able to provide for the achievement of duration and for the appropriate timing of inundation events, which are not necessarily consequences of constraints relaxation projects. We get back at the end of the consideration of all of this to two things. The first is that the policy is the implementation of the SDL adjustment measure projects, and it's outside the committee's remit to consider that policy or whether something else should be adopted. Second, at its highest, the submissions to the effect that the constraints projects are relevant only go to establish the future utility of the projects, because they both enhance the projects in the way I've just been through, but also because the projects exist for that purpose of flexibility and future resilience and adjustability, as has been spoken to this morning. Finally, in respect of surface water, I just note the additional responses given in the relevant technical note 11, in respect of erosion and the exchanges which Dr. Treadwell had with Dr. Brisga in particular. I want to flag this because when I come to the TLM technical note, I'll talk to a lesson learned in that respect. But again, this is an instance in which the committee has that evidence before it and satisfactory project controls to manage those potential effects, if they arise, notwithstanding the matters identified in that technical note as influential on the likelihood of their arising. Page 37 now of the Part C submission takes us to groundwater. In this respect, Mr. Hoxley's evidence, again, is very much consistent with Dr. Treadwell's in the sense that, well, it's both robust and compelling and on the basis of the comprehensive specialist assessment D, but also in that groundwater behaviour will be fundamentally consistent in a natural event with what would result from any managed inundation. And if we assume that the natural events happen, and interaction between the groundwater and vegetation and with surface water are well assessed and concluded to give rise to minor and negligible risks. The committee had the benefit of being able to explore the interaction between the groundwater and the surface water assessments in respect of salinity in particular, and the only matters in respect of which we understood there to be real challenge to Mr. Hoxley's work was in respect of the assessment of removal of single trees or perhaps small groups of trees, and Mr. Hoxley gave satisfactory and compelling responses in that respect. We then move on to a couple of matters in respect of which the committee has not received evidence in the context of this hearing. The first one relates to erosion, sedimentation, and landform stability. The committee has before its specialist assessment E and the relevant evidence that I've referred to in respect of erosion, as well as relevant responses in both Dr. Treadwell's responses to questions and in technical note 9. There's also relevant information provided to the committee in respect of reactive and dispersive soils in that technical note and in the TLM technical note, which I'll come back to. At page 38, the committee will see reference to Aboriginal cultural heritage, which is a matter addressed by Mr. Townsend this morning and earlier in the Part C in writing. There's then historical heritage addressed, in respect of which specialist assessment G identifies modest potential for any effects, and there's a monitoring recommendation that's picked up in an additional EDS, which is proposed in respect of 2 charcoal pits, and I'll just come to that. It's been inserted in this form in table document 177 as environmental delivery standard HH3, and that EDS requires an archaeological investigation and archival survey of the pits prior to operation. The next matter from the Part C then is bushfire, and the committee received Mr. George's evidence in this respect, and as the specialist assessment before it, and in broad terms we'll understand that the conclusions in respect of bushfire broadly are that having wetter vegetation will be better, and that access arrangements are satisfactory in their current form and as proposed by the project. The day one EDSs, the final day EDSs include the recommendation of Mr. George in respect of the total fire ban day guidelines and the addressing of any other periods of fire danger, and they're contained here at EDS BF2, which is on page 3 of the table document 177. I want to share technical note 13, which is table document 171, which contains Mr. George's response to questions from the committee. To briefly step through them, there's a question about the Joint Field Management Program, which Mr. George identifies as basically being caught as part of the reference to current measures and in reliance upon the basis on which authorities currently manage this land. And then there was a question about the fire access road plan conditions from the incorporated document and some discussion in the course of evidence around the classes of tracks and the relationship of those tracks with what are described as the various standards, the strategic fire access road, operational tracks and general roads. So at paragraph of section 13, this technical note provides some additional information in respect of those matters, noting particularly at 13.7 the categories that I've just spoken about. But in what I anticipate will be helpful, the technical note annexes some maps which will assist the committee in having in one place clear outlines of how the EES track classification or road and track classification applies across the project. So that will show the committee where, for example, the class 1A tracks, which are maintenance only, use as existing effectively, exist, and then all the way up to the class 6A tracks, which will provide for effectively the higher standard of passage. So they're provided for Belsar and for Hatter. And the next maps which are provided then are the fire access track classification, which is based on information obtained from DECA. And that shows here at Belsar, you'll see the blue tracks are the operational fire access roads, and the green tracks are general roads or tracks that are not part of the strategic or operational fire access road networks. And so that should illustrate to the committee how those relationships exist. You'll see at Hatter that the tracks are, there's no tracks proposed to be constructed, and it's maintenance of existing tracks, which is proposed. This track, which is Mournball track down the, I'll call it the western side of the project area, but it sort of goes through. I hope you can see my cursor, it's on the left-hand side of the page, of course, is a class 1A track, so again, maintenance only. And that's identified on the last map as a strategic fire access road. That's a clarification from, in respect of DECA's previous advice, that the project areas did not contain strategic fire access roads, which, as I understand it, related to the fact that none of the tracks proposed to be constructed or upgraded are strategic fire access roads. So that's already a strategic fire access road and will continue to be so. And the construction footprint within the EES provides for its maintenance in accordance with the relevant DELC standard. So the final matters in respect of environmental effects are in respect of socio-economic effects and then traffic and transport. They're addressed at page 39 of the Part C submission by reference to each of the specialist assessments which focus on them and go to them. And I won't step you through each of them. There's a quick note to say that the proponent doesn't depend upon any particular financial savings represented by the projects, but rather refers to them in the context of describing policy and potential project alternatives. And traffic and transport, the impacts are characterised as being beneficial in respect of the proposed access track network and maintenance of the existing. So that's the portion of the submissions dealing with the potential environmental effects. And again, coming back to those overarching comments to the effect that in each case, the proponent commends to the committee the proposed project controls, and particularly the EDSs and monitoring requirements in respect of each as being those supported by or produced in the course of the specialist assessments and supported by those experts called by the proponent. The next matter that the
Mr. Forrester, before you move on, we just have a question of clarification. If I could ask Member Bell to ask that of you. Thank you.
Thank you. Just in relation to the access tracks and those figures that you've taken us to, I just wanted to clarify if there is therefore an error in the EES table 6.8, which describes tracks 4A to 4C as new access tracks. I can share that table with you if it's appropriate.
It would be helpful if you can.
Yeah. Apologies. Is that sharing that table?
Yes, it is. Thank you.
Yep. Sorry, it's gone quite small for me. So my understanding was that these matched with the classifications matched with those on the map that you just showed us. And this is example for Belsar, and explains that for A to see a creation of new access tracks.
Yes.
As opposed to upgrade of existing.
My understanding was that that was perhaps in part creation of new and in part existing, but I'll trust that someone's heard this, and otherwise we'll ask that I can get some instructions and come back to you.
Thank you. I'll stop sharing.
Yes, thank you very much.
That was my only question. Thank you.
Thank you. I'll hopefully have those instructions soon and come back to you as soon as I can.
Thank you, Mr. Forrester.
In the meantime, I'll turn to pages 40 and following of the submission to briefly identify that insofar as the committee had questions about the Biodiversity Expert Review Group, the Part C provides some additional information over those pages, and the committee has also been provided with the terms of reference for the Berg at table document 181. Table document 181 is effectively summarised in the Part C submission, but it provides the overarching terms of reference for the independent expert review group, and then the biodiversity expert review group, which exists as a subgroup. And the committee will see that its processes involved and included processes of independent review. Its responsibility or accountability or relationship was with the project control group. So it was not a body created or convened as a part of the somehow as a part of the project or within its partner agencies, but rather was appointed as a body to hold independence and to bring its expertise to processes of peer review of documents. And the reason for its description as the Biodiversity Expert Review Group is because it brought significant experience and skills to the manner in which the EES assesses not just impacts, but those potential and predicted benefits in respect of particular matters. The committee will note that as well as assessing the specialist assessments which were within the scope of the expertise of its members, the Berg also reviewed the assessments of overall improvement to biodiversity, as well as the EMF, and throughout the process of its development by Arthur Ryler Institute, the ecological MER plan. At paragraph 147, there's a brief outline of the typical process of Berg review, and the committee will take from that it involves some back and forth and discussions and correspondence and so on, but ultimately that it is an iterative process such that its processes of peer review were involved assessments of the draft documents before exhibition, and for that reason its reports aren't exhibited with the EES. Their reviews have varied from addressing specific and confined matters and technical matters to changes to overall assessment approach and reporting to ensure adequacy. At paragraph 149, there's a description of a number of sessions which were convened with the Berg as central and ongoing meetings. Now, those are independent of the processes of review which existed in respect of particular documents, but in essence ensured that the Berg was appraised of and was able to provide its input into the development of overall approaches to the project's development and the EES's development. The final thing to note, I should note, is that there was a question along the way with in respect of consistency of the Berg approach with the DELP advisory note in respect of peer review for the purposes of EESs, and that advisory note is part of the material with which the Berg was briefed and is the basis upon which the Berg was appointed. That is to say, is consistent with that approach in the sense of providing for that independent external body for review. And as we note at 150, the basis on which reports weren't exhibited is because they were those iterative documents and not final peer review reports as such. The next section of the Part C submission goes to the proposed project controls. And before I get to that and the final day controls, it would probably be opportune to turn to the technical note in respect of the Lower Murray, the Living Murray project. I'll share it on my screen and step through it. So this is table document 184. And I'll just step through the structure it follows and what it provides. It's provided in respect to particular requests for information and then a request for further information in response to one, and exists to provide further information about previous environmental watering projects, which with a particular emphasis on the Living Murray. Excuse me. The committee has seen both through the documentation that the proponents provided and through the introductory and explanatory presentations, as well as in the course of evidence, that examples of environmental watering across Victoria and elsewhere are broad and varied. That said, there are very many which receive environmental water by way of the operation of infrastructure and works, which is akin to those proposed as part of this project, these projects, albeit at very much differing scales across the different wetlands. You'll recall on day 1 or 2, Mr. Callerman provided those examples of relatively small areas of wetland and relatively small weirs and similar structures that are used in that context. And at the other end of the spectrum, there are, of course, the projects in the TLM, which are of most comparable scale in terms of the area of floodplain watered as a consequence of the operation of the infrastructure and works. Paragraph 2 of this tech note identifies that the presence of infrastructure and works of those varying degrees is almost ubiquitous across watered floodplains and wetlands. Of course, there's environmental watering of channels and as in the case of the Avoca River, which was referred to, there's environmental watering there, which finds its way into other places just by virtue of improving or bringing hydrology closer to natural. But in the case, for example, of the WetMap program, which is the Victoria's, I suppose, peak wetland monitoring and assessment program, all of the wetlands which have received environmental water and which it has monitored receive water through pumps, pipes, channels and the like. There's the TLM sites, and there's those other examples, such as Little Haywood Lake that Mr. Fruit eventually identified.
Mr. Forrester, could you just make that a little bit larger, please?
Of course.
Great, thank you.
So from paragraph 3, identifying that the focus of the tech notes on the previous TLM projects as those which are of most relevance to these projects, the 6 there are the 6 projects identified here, and some information provided in terms of how TLM came to pass. Now, TLM is coordinated by the MDBA and obviously involves the participation and involvement and the responsibilities of a number of agencies and bodies across Victoria, South Australia and New South Wales. And in practice, that means that the monitoring, evaluation and reporting in respect to them is a matter that's dealt with in different ways across the sites, but ultimately under the coordination of the MDBA. Paragraph 5 explains where the sites are and who manages them. And you'll see that most of them have some Victorian involvement. So Barmah has part Victoria in the Gunbower, Kundrik, Perracuda site. The Gunbower site is in Victoria and Kundrik, Perracuda, New South Wales. Hattah is obviously relevance here. And then there's straddling South Australia, New South Wales and South Australian sites. The next paragraphs of the tech note refer to the processes around those sites, and they are multi-layered and complex, of course, and as relevant across the jurisdictions. That is accounted for to some degree in respect of operations and coordination of watering and so on by the SCUBEC, which the committee's heard about. as well as the operations of the CHU and of course the state environmental water holders through their requirements and practices of engagement with other agencies. Now, the tech note does provide here detail in terms of annual reports for the SCUBEC and the publication of reporting in respect of the Living Murray icon sites. And given that reporting now extends in some instances, I think up to 15 years and in most up to 10 years, the practicalities of summarising it all for the committee are obviously an issue. So what we've done is provide the links to that reporting and then identify in this tech note some summary conclusions in respect of or which apply across sites before turning to the Hatter Lake site in particular. There's a qualitative description then of the key learnings taken from the sites in respect of red gum tree health and particular examples for Hatter Lake South and Gunbower, which established through monitoring and evaluation that condition improves and cover improves as a result of environmental watering. In terms of black box productivity and habitat value, similarly at Hatter Lakes and at Hatter Lakes, the vegetation and faunal response were also promoted by environmental watering. Aquatic productivity, consistently with Mr. Marsden's evidence, also improved, and there's reference there to Barmah-Millawa monitoring. The same story in respect of small-bodied floodplain fish, which we'll also come back to. There's reference to waterbird monitoring. And as I scroll past, it's perhaps convenient to identify for the committee that there are monitoring reports cited in respect of each of these conclusions, which are presented as high-level conclusions, as I've said. There's a section here at paragraphs 19 to 23 in respect of monitoring, reporting and adaptive management, and evaluation in there too, I should say. And there's brief statements of things I'll come back to when addressing that particular topic. But in essence, they go to establish the fact that each of those practices are, and in a sort of a semi adaptive management principles have been applied by the managers of the TLM sites, have informed adaptive management processes. So, for example, the committee might come to see, well, there are references in our materials in respect of the overarching policies of, for example, the Commonwealth Environmental Water Holder in respect of monitoring, evaluation and reporting. And those overarching policies then guide what's done at individual sites. And what's done at individual sites then informs the redevelopment or renewal or revision of the overarching policies in respect of how reporting is carried out and the implications of that reporting or monitoring and reporting for management decisions. The tech note then turns to the Hatter Lakes project and identifies the particular matters that the committee requested specific information regarding. I'll skip past the summary and move quickly through the note. First, it identifies the approvals process. So I think in a way that's somewhat consistent across at least Victorian sites, the processes are somewhat similar in the sense that the approvals are somewhat similar to those which the present projects would be required to obtain in many ways. And so the Hatter Lake site was subject to referrals under the Environment Effects Act, the EPBC Act, and notification of the Native Title Act. It was determined that by the Minister under the Environment Effects Act that no EES was required, and under the EPBC Act that no, it wasn't a controlled action, as long as conditions were met. And so it's those conditions which provide the overarching basis upon which the site's constructed and operated. The long and short of it is the Environment Effects Act decision requires the preparation and implementation of an environmental management plan. And so it's operation in accordance with that plan, which is, I suppose, the overarching document. This table identifies the series of permits and consents and approvals that were obtained, which, as I've noted, are similar to those listed in the case of these projects. In this case, in the case of the Hatter Lakes project, a planning permit was issued. It authorised the buildings and works, the infrastructure, and native vegetation removal. And the native vegetation removal proceeded on the basis of an authorisation under clause 52-17 in circumstances where the conservation works exemption was not in the planning scheme yet. And the DSE, as it then was, effectively agreed that the project would provide offsets, as was then required by that clause, by providing for benefits on the land which was watered within the protected land, so within the Hatter Lakes South site. We go on to note a little later in respect of native vegetation that in that context, the basis on which those offsets were provided was on the basis of a calculation of gain or net benefit, having regard to something like 300 hectares of the watered site. Overall, the Hatter Lakes infrastructure, Hatter Lakes South infrastructure permits the watering of about 6,000 hectares. So in that case, on the basis that the delivery of water would be addressing precisely the same issues which are identified as those issues agreed by everyone in respect to these floodplains, the offset was provided, if you like, by way of identifying that about 5% of the floodplain would benefit. There are the other permits which are listed here. There were some New South Wales approvals, I think in a similar vein in the context of the need for a New South Wales development application for the current projects for temporary pumping. It's a similar story there. The nature and scale of infrastructure is assessed at section B, or pardon me, described at section B, and there's a plan and a schematic diagram provided at attachments B and C, which identify where the infrastructure is. Attachment D provides some photos of key works and infrastructure. And then here at paragraphs 33 and 34, there are two tables which allow a direct comparison of the levies constructed for the Hatter Lakes South and those proposed as part of the Hatter Lakes North project. And the committee will note that there's similarities in their scale in terms of both their crest elevation, noting that Hatter Lakes South crest elevations are higher. Freeboard is similar. Maximum heights are, broadly speaking, similar in the sense that the maximum height of the K10 causeway is 3.5 metres because of its topographical location, and the other levies tend to be smaller, and the total lengths are provided in the right-hand column. So the native vegetation matters that I spoke to are then set out at section C, with identification of the amount of native vegetation removed for the Hatter Lakes project, and those matters that I've spoken to in terms of the offsets. Section D then talks about unexpected effects, and it does so identifying that as far as adverse effects or unexpected effects, they have been limited over the 11 or so years that watering has taken place. It's been identified that there's been some scouring where there has been a higher than anticipated afflux at inlet structures, and there's been erosion protection measures implemented and the issues have been resolved. The monitoring carries on, and for example, there's, by way of an example here provided from 2020, there's ongoing research carried out into, notwithstanding the fact that it hasn't been identified as an adverse impact or a problem, there's research ongoing into, for example, how low dissolved oxygen events can be minimised or managed using and during environmental watering. There are some specific matters in respect of specific categories of fauna and species, which are monitored and informed. Traditional owner involvement is set out in some detail at section E, and this is using terms and referring to matters which you've been taken to already this morning, including the specific Living Murray Indigenous Partnerships project. Of course, it's Mallee CMA that is responsible for the relevant engagement in respect of this site, and similar procedures to those you've heard about this morning are those which are implemented there. It's been noted and lauded for those efforts. The CHMP is addressed, as well as operational involvement of traditional owners and interested parties. So in terms of specific learnings applied to VMFRP at section F, this was a specific question of the committee, and the tech note identifies that really the primary set of learnings to be applied will be the whole suite of data that's been produced by way of the monitoring, evaluation and reporting programs. And that might be an unhelpful answer in the sense that there's not a specific learning to be applied when I say that. It's also the case that, particularly because of the close relationship between Hattah Lakes South and Hattah Lakes North, it's expected that monitoring, for example, of the black box and red gum responses that I've referred to and that the tech note earlier refers to, will be able to directly inform management in respect of Hattah Lakes North. There's references there to the monitoring which has been carried out, which will inform that. In addition, there are some very specific learnings, some of which I might say descend to detail beyond that which is within the scope of the EES and the EES process. But in any event, there are specific design matters which have had management implications for the people operating the infrastructure and making decisions about how it's operated. Issues to do with pump stations and bearings and powering and so on. Noting that specific changes or differences in this project represent solutions or avoidance of those problems. At 57B, reference to the erosion of waterways where water returns to main watercourses, and in that case there was no protection measures. So this is, as I understand it, where water returns to the Chalker Creek, and there was no erosion protection in place, and indeed it was not considered or fully considered at the project design stage. By comparison, and consistently with discussions that have been had in the course of the hearing, the VMFRP has been conceived to incorporate that consideration and to incorporate robust erosion protection measures from the outset, as well as management controls. The scouring and structures issued, I think it's you'll infer from this that there's been issues with structures being blocked and the use of bollards and screens to avoid that, such that the water doesn't do what it's not meant to. Seepage issues to do with geotech investigation and VMFRP proposing to remediate that through contractual hold points. And then given the nature of the approvals and as I understand it, primarily the fact that it was a planning permit that authorised relevant activities, there have been constraints in terms of the ability of the project and its operators and managers to be able to respond to ongoing issues. So some operations and maintenance activities where they've involved the works to carry out matters which might include erosion protection and so on, there would be a requirement for a new permit or an amendment of the permit, by contrast with the situation provided by this incorporated document, which simply provides for the appropriate process by which those matters can either be approved or are approved. So then there's the attachments that I've referred to, including the maps and photographs that are provided by way of examples. It's instructive to look at the particular examples which are in attachment D in terms of the regulators which are present, and in terms of the levies. This is Bitterang levy, which is at the southern end of the Hattah Lakes North project, of course, at the southern end of the Bulka area. And with reference to that and the breakout levy, the committee will see that these levies, when constructed under roads, and as has been referred to at the outset of the hearing, provide for incorporation with the landscape and aren't perhaps the structures that might appear in one's mind. So that's that technical note.
Mr. Forrester,
Voting.
would be a good time to have a break if
Yes.
that seems a logical time.
I was about to say the same thing, Madam Chair. Yes, it's that would be good. Thank you.
Thank you. I'd just like to mention as well, the committee will need to rise at 4:30 at the latest. So just to give you a warning that at probably about 4:25 we'll just need to be wrapped up so that I can make a few closing comments before we do officially close the hearing as well. So can I just ask on that matter, do we need to take a 10-minute break rather than a 15-minute break?
Look, I think it'd be better to do that, yes.
Okay, great. So it's 3:22. We'll come back at 3:32. We'll see everybody then. Thank you. Thank you, everyone. Welcome back. I'll hand directly to you, Mr. Forrester.
Thanks, Madam Chair. I've come to the point in the Part C submission, which starts at page 42 and addresses the proposed project controls. And in addressing you on that, I'm going to address a couple of other matters which have been foreshadowed and which relate to the project controls. But what I'll do is start by identifying, as set out at paragraph 151, that in proposing these projects, the proponent is proposing to the committee the proposed controls, and they're an inherent part and an integral part of the projects themselves, and provide for the basis on which benefits will be achieved and maximised, as well as those matters involving the avoidance, minimisation and management of potential environmental effects. In the course of the hearing, and particularly in the course of cross-examination of the witnesses that the proponent has called, there has been little attention to the proposed project controls by submitters to this committee. And on that basis, the proponent is commending to the committee the final day versions as controls which have been through a robust process and which are premised upon robust assessments, and as being the appropriate ones to be put in place in respect of these projects. The committees will be familiar with its reporting tasks in these respects, and I'm going to address the committee primarily on the substance of the controls and what's before it, and make a couple of other notes on the way. The first thing I'll do, though, is talk to the incorporated document. And as the Part C sets out, the incorporated document forms, I suppose, the central part of the draft planning scheme amendment, which is addressed in Specialist Assessment K in terms, and which is supported by the draft explanatory report and strategic assessment report exhibited in the draft planning scheme assessment attachment. Now, the incorporated document in the final day version is tabled document 178, and we've done two things in this document. The first is to identify throughout, or to include throughout, comments in terms of why changes have been made. And this comes from a request or a comment early on, I think from you, Madam Chair, in respect of explaining why changes have been made or where things have moved. So hopefully that's helpful to the committee. The only change in respect of the incorporated document, which I need to take you to and which is in place in the final day version, excuse me while it's flicking back and forth, relates to the native vegetation question. And you've heard Mr. Townsend in this respect, and on the basis that it's appropriate that this incorporated document deal with the projects in the context of their achievement of improvements for biodiversity and not just the typical parameters of the equivalent parameters of clause 52.17. That clause 4.5 has been deleted. In the context of the incorporated document and the draft planning scheme amendment, it's appropriate for me to note now, and before I move on to the other documents, that in the context of the committee's reporting tasks, one thing it's asked to do and tasked to do is to advise the minister as to the adequacy of processes to date in respect of the draft planning scheme amendment. and it's the proponent's submission on the basis of those supporting documents that I've identified in terms of the reports exhibited, in terms of the exhibition of the draft planning scheme amendment together with the EES, and in terms of this public process in respect of the EES, including the draft planning scheme amendment, in which submitters have had the opportunity to make submissions in respect of and engage with the proposition of and the detail of the draft planning scheme amendment. The committee should be comfortable in concluding that those processes carried out to date in respect of consultation, engagement and public process more broadly are adequate, and should recommend to the Minister that no further process is required in that respect. The next thing, of course, is the environmental management framework, and I've taken the committee to the changes which are proposed in the final day version of the environmental delivery standards, which is table document 177. I should note, I'm not sure I did, both of the final day documents 177 and 178 show track changes, but all of the final day changes are the ones highlighted in yellow. And so that they should be apparent to the committee, and I understand it has those documents and word versions of them as appropriate, and the committee will of course receive any comments from others in respect to them. At this point though, rather than going back over the EDSs and the proposed changes or inclusions in the monitoring requirements, I'll note there are a couple of committee questions which are responded to in the Part C submission. First, in respect of the possibility for the projects to be operated to not inundate private land, and the implications of the recent flood for the delivery timelines, and they're addressed in Part C. The only other matter that I'd like to address in terms of the substance of the proposed project controls goes to a matter which has, or two matters really, which have come under criticism, or which have been conceived of as matters upon which to criticise the projects and the EES, and they relate to questions of monitoring, evaluation and reporting and adaptive management. I'm not going to labour these points because I took the committee relatively quickly, but I took the committee to the EMF when discussing the day one documents. But it's important to note the sheer volume of requirements which are in place in respect of the existing environmental watering framework, and which will be added to and refined, made a project-specific obligation by the proposed EMF. This is particularly pertinent in terms of these two things: monitoring, evaluation and reporting, and adaptive management. And those issues are addressed both in the Part C submission itself, from paragraph 33, and in respect of the attachment, which is tabled document 172 at paragraph 17. And just wanted to very quickly share on the screen the EMF as I speak to these matters, rather than reading the EMF. I'm just opening up section 18.8.4, which is the operational performance management section. And through this section of the EMF, I'd invite the committee to read carefully and understand the requirements of the EMF by reference to relevant documents in terms of short, medium, long-term monitoring using a variety of different tools and measures. There's evaluation against key evaluation questions, which are either have been developed in part through the development of the existing ecological plan, and which will be updated on a regular basis, which will be informed by the Victorian Murray long-term watering plan objectives, and which will be prescribed in the future site-specific environmental water management plans. There is a cycle provided for in the EES and EMF for the data produced in accordance with the ecological plan and all monitoring and reporting to both feedback into management for the purposes of the VMFRP projects, but also into the statewide Murray programs database, such that the data is not just of utility in respect of future management of these projects, but also other sites across Victoria. And in this context, it's also important to note the various monitoring programs which occur in respect of wetlands, which have been identified, or in respect of wetlands and environmental watering, which we've identified, including the WetMap program, VMFRP, which is the Victorian Environmental Flows Management, monitoring plan or program. There are specific monitoring programs carried out by the Commonwealth Environmental Water Office and the VIEW, MDBA monitoring programs, including basin condition, and the committee is also familiar with the TLM specific monitoring I spoke to earlier. And there is, of course, what I call private science or academic and other research that is conducted on the basis of these floodplains and wetlands. The monitoring and evaluation and reporting requirements then of the EMF, under the auspices of all of the relevant policies and in the context of the balance of monitoring programs and requirements, are very much meaningful and will be productive of data which is useful in that broader sense and to the future adaptive management of the projects. In that context, it's important to understand that's I suppose where adaptive management it comes into play. Adaptive management isn't proposed by way of kicking the can down the road on responding to potential environmental effects. It is proposed in accordance with the very much recognised policy in respect of environmental watering and practice in respect of environmental watering, which is dependent upon the carrying out of monitoring, evaluation and reporting consistently with what have become well-developed frameworks and processes, identifying and proceeding upon the basis of these key evaluation questions, threshold criteria, and so on, to ensure that they produce data which can best be used in adaptive management. Adaptive management, thinking back to the part A, being identified in all of the relevant policy as the primary and most appropriate tool for the management of environmental watering. At paragraph 35 of the Part C submission, there's a brief summary of the effect of the requirements of the EMF in respect of monitoring, as well as other programs, and in respect of the requirements in respect of adaptive management. In those respects, the committee should be very much satisfied that the proposed project controls are consistent with and focused on the application of and development over time of flexible and adaptive management procedures to ensure impacts are minimised while beneficial outcomes are maximised. So to the extent to which the projects have been criticised, or to the extent to which it's been suggested by some submitters, there is no robust framework for monitoring, evaluation and reporting, those submissions simply can't be sustained. The one other aspect in terms of inputs into adaptive management that I should touch on before concluding and handing back to Mr. Townsend is in respect of the expert elicitation process and what the proponent conceives as its relevance in the scheme of things. This is particularly addressed in table document 172, the attachment to the Part C submission, from paragraph 53 and onwards. And what that submission seeks to do is set out the thread that has led to the conduct of the expert elicitation process, which is very much consistent with what you heard from Mr. Chapman this morning, in respect of its origin in the context of the idea that everything had to be quantified or that values had to be arrived at. And it has also been a thread which has featured at key stages Mr. Frood, who is very much an interested party in this process and whose demonstrated well his particular position in respect to the project. So those comments are made in the Part C submission, the attachment to the Part C submission, and I would note them and understand the committee will have read through them and will in arriving at its conclusions. But in short, the position of the proponent is the expert elicitation process is of little, no weight in the context of this process, because first, it has no real implications for the assessments of overall improvement to biodiversity, but also because at its highest, it may have utility as one input into future decision making, which will be, to which regard will be had, filtered through an understanding that it is not site specific, that it provides what it provides on its face and nothing more and nothing determinative. So it would be unsafe and inappropriate for it to be applied in the context of this hearing as influencing or somehow describing how benefits might or could be achieved or otherwise. But the proponent doesn't rule it out as a potential future source or input into future decision making as one aspect of the adaptive management framework. And with that said, I'll just emphasise that the Part C submission has included those comments in respect of the monitoring and evaluation propositions, and has finally concluded in respect of the project controls as a whole and in respect of the draft planning scheme amendment that those are in suitable form, have been subject to suitable process and should be recommended by the committee in the final day form. Unless there are specific questions of me, Member Kendall, I don't yet have instructions on the question about the tracks. Perhaps I can hand back to Mr. Townsend and I'll be sure to make him aware if those instructions come in.
Thank you very much, Mr. Forrester. So no questions from the committee at this stage. Thank you.
Thank you, Member Kendall.
Need to pop off mute, Mr. Townsend.
Sorry, thank you again. Member Bell, so you know that there are emails flying around at the moment. Some people are at their desks, others are in Mildura for other reasons. And if we can get an answer in the next few minutes, we hope to. Can I use that as an opportunity, Member Kendall, to say this as well, that we know the committee have been quite terrific, I've got to say, through this, if I may, with asking questions and wanting to get answers. We've tried to keep a list and we hope we have responded to them all. Although you will close the hearing today, we would expect that if for some reason the committee finds we haven't answered something or you do have something else to ask us, by all means, that's in your hands, and we would consider it our obligation to reply in writing if a subsequent question emerges. I'm not anticipating that, but we are hoping that in documenting for you along the way with our emails what we've responded to or where we have, that we hope we've covered the field, subject to Ms. Bell's current question. So when it comes to any documentation from here, the opportunity for comment on the documents, we don't know if anyone's taking that up. We would ask, if necessary, that the committee reiterate the obligations and the limitations on scope. It's quite unhelpful, and history has proven this to be the case. If, regrettably, a submitter files a document under the auspices of it being a drafting suggestion or based on their case that introduces argument or contest not otherwise tested in the proceedings. And I think, Member Kendall, you were clear about that with the DECA this morning, although I anticipate they'll keep, you know, they must understand the process, or will, but it should apply also with anyone else. And I'm sure that'll be clear, but we would like to avoid anything more than that being an exchange of documents or subsequent things. It's possible, if any submitters are listening to this, or including Mr. Decker, they can always contact the proponent with suggestions, and matters can go to the committee on an already discussed or agreed basis as well. So that's an open invitation to, in those circumstances, should anyone be listening.
Mr. Townsend, just while you're just mentioning that, and certainly I was going to reiterate that this afternoon for the reasons that you just mentioned, I will just note that we have received one submission already with comments on the final day documents from Dr. Murdoch. So that should be in the share document platform at the moment, which is, yes, anyway, I'll just, yes, so that's been received and submitted. Thank you. And sorry, that's document 185.
That perhaps, Member Kendall, you can, if there isn't a specific direction, consider when you close the matter in a few minutes, what your expectations from the proponent are as the final step, or if any, whether you want us to consolidate a day 3 with anything we agree with out of those, and then send that in, which I assume is what you'll probably ask us to do. Obviously, whatever you wish, we will cooperate with, but my suggestion would be that you invite us to do a further version incorporating any of those matters we agree with, but otherwise assuming we don't, rather than engaging in your discussion or argument around it.
Thank you, Mr. Townsend. And with your suggestion of that, because it is something I think would be good to explore, make a decision on today, would you be looking for a week turnaround from the time that the comments are received from parties?
I'm sure that's more than sufficient. Yes, let's say that.
Okay, thank you. So I will say at this stage that the committee agrees that's an excellent suggestion, and we will, in our email to parties at the end, issue that as a direction. Thank you.
And if for any reason there's nothing to, we won't produce a day 3 for the sake of it. If it's nothing responded, we'll give you an email either way to let you know what the position is.
Thank you.
I had allowed myself for a couple of minutes to revisit any gaps from the submissions earlier. But after Mr. Forrester's presentations and traversing of those, I'll spare you that at this time of day. But instead, I'll just make a couple of points that I would like to suggest are clearer and have emerged through the afternoon and are well said in hindsight. They were touched on this afternoon, so I'll do it in one-liners. But the first is around adaptive management, that at the end of the proceeding, we would hope that the committee appreciates that whole concept as more than what might seem when someone approaches an EES, that it's a response to unexpected outcomes, that the principle of adaptive management is much more scientific, much more attached to the monitoring and evaluation and the feedback loop as it was described, and actually is what gives the projects real potential to achieve the benefits that they seek to achieve. And so that adaptive management is really integral to the very positive outcomes that are sought and the achievement of gain. Adaptive management is not just oh, we won't do that again, or that was we could do better than that type response, or worse, that it would be as Mr. Forrester put it, just to kick the can down the road to see what the impact of inundation is. It's much more considered than that, and I would suggest that comes through the documentation and is better understood in hindsight. And similarly, it's one example, we'd say, of why the process hasn't really been, or the process of adaptive management and monitoring and that component of operations hasn't really been advanced very much by the expert elicitation process. But as Mr. Forrester said, it's a piece of work. It abides, and there's it certainly it need not do any harm, but it hasn't in our submission delved or come from the level of information that will be at hand through the adaptive management process and all of the special assessment work and field work, existing conditions appraisals that have been done for comparison between existing and future circumstances and information that provides. I would have said, and without going to it, that in our Monday submission, the attachment to the Part C, it from paragraphs 53 through to about 60, we had set out, we had tried to ascertain and set out for you in submission how we think that process even came about. And we think both in the circumstances of its origin and its closure, the expert elicitation process, and then putting aside the complications of not being able to test it and Mr. Froude's anonymous work, it really has to just stay as a satellite to this process and the core documentation. Acknowledged it exists, but it's certainly not a document that could in any way be at the level of what this committee's work is, or having the oversight of what this committee's doing, or in any way held up as a document that is somehow above or judging the EES process. It really has to be seen as a discussion that occurred as an exercise in a particular context and without being thoroughly scrutinised. So the reason I say those 2 points, though, is really moving to broader matters of process. The first is a practical one. Member Kendall, we have followed up for you just in case there was a change on the question of site inspection abilities, and we understand that the answer is no, there's no change, but I have a further update because Parks Victoria are attending the traditional owner consultation meetings in Mildura today, and they've spoken with Ms. Cox and have indicated that their expectation is parks will not be open before April, and that may influence you in whether you're doing private inspections or not, and it might become clearer, no doubt it's on their website. But I thought I'd let you know that today, just as the news hot off the press. But what will be happening over the journey from here is that the committee will be moving to other projects. And I just wanted to, in signing off, as it were, today, draw your attention to the terms of reference and say something about how VMFRP or LMW is hoping to have assisted the committee, whatever it determines, not just in this process, but in subsequent processes. And so the effort in the central package was very much to document a very comprehensive Part A submission that includes, as you will have already seen, a number of matters that are common to all the projects. And within that, there have also been a number of concepts navigated through this hearing. Examples I just gave you, what adaptive management means, what the expert elicitation process was, and there are others. I think I would suggest to you the scope of the hearing. In the first round, there's more of an inclination to hear submissions, even though they're about water policy and the like. So I just wanted to say that, Member Kendall, because for the committees more generally, under your terms of reference, there are two, there's on the one hand, the direction that is consistent with the preparation of the EESs that reports are required in each case. And in the reporting at your clause 47, each report is specified as for each of the 4 assessment packages having to do a written report with those matters having to be addressed. However, in 2 locations in your terms of reference, first of all, under the round table at term of reference 37, the SIAC, and that means in all of the projects, may determine the scope of specific evidence and submissions to be presented. And at quite expressly at term of reference 44, the committee should, as appropriate, use relevant understandings gained from SIACs, plural, other public hearings or roundtable forums, including to assist with common matters and consistency. And the reason I raise that now is that it seems to the proponent that it's worth the committee, when you report on this matter, in the committee itself being prepared and able to conduct efficient subsequent hearings at the next directions hearings by perhaps letting the parties know where you would or would not be assisted by information, particular to those projects. I say that because once you report, there's no guarantee that you will have a minister's assessment or any feedback from the minister, but the committees will know what you have reported. And it seems to us that these terms of reference enable you as a committee or in subsequent committee to direct at directions hearings what you need to be a focus in subsequent hearings, knowing what you have learned or reported on, even if the parties don't know. And I thought I'd just draw that to your attention today, because it might benefit the committee in the way you might be writing your report around matters that are common or consistent to the projects, and being able to adopt that for yourselves in other projects. But I say that by way of assistance for other projects in the process, but also on the premise that we're hoping on behalf of the proponent that there'll be, that what we've hopefully helped you with through the last few weeks will result in real cost and time efficiencies in subsequent processes. And obviously that always remains to be determined on the day and at the hearing and according to what issues committees have to deal with. But at least as in principle, we thought if we raise that today, it might be something the committee can take with it after today, and it's the way it prepares its reporting, and hopefully in understanding why, even in this case, we might have gone to more detail and covered more matters at more detail than we might be expected to in subsequent matters. So I wanted to draw that to your attention, if I may. I've just got a note that in reading between the lines indicates to me that Member Bell has raised a good question, and that it's not capable of an immediate response on email. And we wonder if we could have your leave to give you a written response, noting that that's unfortunate. We'd like to close the hearing without saying we need to do that. Do we know how long we need? If we did it tomorrow, would that be acceptable to the committee? My guess is,
and it will be on the proviso, as you mentioned earlier, Mr. Townsend. If there are any other matters, we can.
Oh, of course.
Have no issue with receiving that. If we have any further questions, we can come back to you.
Well,
I'm also mindful of the drone footage that you mentioned this morning. I don't know whether that has come through. And again, that if that does come in after today, we may come back to you if we do have any questions.
It is definitely coming in after today. This morning, I'd asked, could it be by the end of the week? And I didn't have an answer then. So look, I think it's because it goes to someone's doing the technology. We will put every effort into encouraging that to be done as quickly as possible. But unfortunately, I can't tell you what that is. But I'll ask them all to try and make sure it's done by Friday.
Thank you.
And I apologise for that. It was just one of those things. We thought it was being done one way, and I was uncomfortable about it. So we'll do that, and of course we leave that offer open. Obviously, the committee have other questions. Of course, none of us want it just to roll on to a written, and we're certainly not going to be volunteering information. But we'll limit ourselves to the table 6.8 response, the drone, our 7 day later submission of day 2, day 3 documents where we are adopting, or perhaps with a drafting change, accepting a suggestion. And unless we hear from the committee, we'll take that to be the limit of outstanding matters that you're expecting us to address.
Thank you.
All right, I'll just look at my colleagues, if I may glance across and see if there are any other matters. Member Kendall, on that basis, it's 4:05, and unless you had any questions of me, I would take the opportunity to thank not just all the committee members, but the parties, and also in the circumstance of us being all around Victoria, the various agencies that have assisted us. It's not just, as you know, my direct client as such, but you've seen, I think you're well aware that Mallee CMA have been helping where they can, and others. And if I can just, while I'm on screen, take that opportunity for our part to thank others and the submitters who've come along and in good faith made their points clear. On that basis, Member Kendall, that would be the submissions on behalf of Lower Murray Water.
Thank you very much, Mr. Townsend. And we are finishing well ahead of time, which is greatly appreciated as well. So thank you very much for that. There's just a few closing words that I need to make before wrapping up this afternoon. So just a recap. We will send out an email following today's hearing confirming those post-hearing processes and timeframes. And I'll just run through a few of them for the benefit of the proponent and other parties in the room. So in accordance with the directions, the original directions 42 to 44, we do invite parties to comment on the proponent's final day amendment documents and reiterating that the committee will not consider any content that looks to revisit merit, and we very, very strongly implore parties to restrict their comments to drafting only for the benefit of all involved, given the stage of the project that we are at. The committee does reserve the right to reconvene or ask any questions if there's anything that it is unclear on of a critical nature when it's reviewed all of the material in detail. So we will keep parties informed if something does arise. And I'd just like to confirm for all parties as well, there are obviously a number of submitters to the committee who have not presented to us during the hearing process, and we will of course consider all written submissions provided to the committee, not just those presented at the hearing. From this point onwards, the committee won't accept any further material other than that directed by it or discussed and requested through this hearing process. And the committee is required to provide its report to the Minister for Planning within 40 days from the last hearing day or the last information being provided as directed by the committee. In line with the terms of reference, the committee will issue its report to the Minister for Planning with recommendations on how to proceed with EES Central. And just a reminder for all parties that there is information about the committee process and the terms of reference of the Engage Victoria website, if anyone is interested. I do have a few thank yous I'd like to make, but before I do that, I will just ask if there are any questions from parties about the process from here. Dr. Kelly, I'll come to you.
Good afternoon.
Good afternoon, Dr. Kelly.
Just that I hope that through mentioning that Parks Victoria have informed Mr. Townsend that the parks are not going to be open till April, that does not, he's not indicating that he's suggesting no committee members can come and do a tour on their own personal.
Thank you, Dr. Kelly. I'll take that as a comment, and the committee will certainly consider its options. Thank you. Thank you. So if there are no other parties with questions about the process from here, I'd like to close with a few thank yous on behalf of the members of the committee. So Member Kirsch, Member Bell, Dr. Brisger, Member Crothers and Member Ham and myself. So thank you very much to all submitters and parties for your participation. I'd like to acknowledge and thank Mr. Townsend and Mr. Forrester, who are representing the proponent and associated agencies, and the proponent's team for assistance throughout the hearing, hosting the hearing, managing the document sharing platform, and responding comprehensively to the committee's requests and questions throughout. And I'd just like to note as well, the committee has appreciated hearing from the officers in the proponent and associated agency organisations throughout the hearing. So if you could pass on our thank you. Also, of course, to acknowledge and thank the community and individual submitters for their efforts and commitment to participating in the committee process. A final thank you to the Planning Panels Victoria team for assistance throughout the hearing process, and with particular mention of Ms. Amy Selveridge and Ms. Gabrielle Truce. So on that note, I will officially close the hearing and thank you very much.